Please seek your lordship's permission to mention the matter fixed at 2 o'clock. Your lordship single bench, Miller.
No, don't mention now.
But in fact,
Yes.
so fixed at 2 o'clock. In fact, the mother-in-law of Mr. Vishwal died last night. He has gone for cremation. The entire brief and the evidence and affidavit we filed today is with him, Millard. So I pray for Monday, Millard, on behalf of Mr.
No, when the matter reaches you, make a mention. At 2 o'clock, if single bench matter, why are you mentioning in the division? Yes.
Quickly list item number 18.
May I please? अरे से कौन काढुची से एटा कौन तो सिंगल बेंच आइटम 18 कर दले yes yes madam agora que isso ainda Last occasion, I have filed 2 decisions. Lordship has directed 2 decisions more have to file. No, you placed the evidence of those eyewitnesses on the other day. Yes. And we asked you that how you will demolish this evidence of the eyewitnesses. Then almost you said that they are consistent with each other. Yes. The assault was by Dhannakuta Pohurani, right? Yes. And the assault was made on the vital part of the body like head. Another blow was given on the chest. Yes. And there was hematoma as it appears from the doctor's evidence. There was fracture of the reefs also there, that is there. And the doctor specifically stated that the deceased died of the injury to the head and its complication thereof. So one thing the doctor has not stated that it was sufficient in ordinary course of nature to cause death. Yes. So Mr. Tripathi pointed out one decision of the Honorable Supreme Court. You pointed out 2 decisions of one of this court as well as the Honorable Supreme Court. So have you found out any further decision? Yes, I have filed 3 bench decision. देखिए बीटा कॉपी ଦେଇଛନ୍ତି ନା? These are the 2 decisions you have filed. Okay. Yes. 1 by 3 judges benches. 2016, 3
Yes.
SCC 317.
Yes.
So which paragraph you want us to go through?
Para 13.
13.
13. 13.
13.
Last para. Last. But
Please read it out.
here is the gunshot injury as fired. It was hit in the thigh.
All right. Please read it.
Para 13.
Hmm.
Keeping in view of the above principles, when we examine the facts of the present case, the deceased sustained gunshot wound of entry 1.5 inch on the back and inner part of left thigh. 6 gunshot wounds of exit each 1.5 the size in front of middle left thigh. Due to occurrence in the morning at the barber shop of the deceased, the appellant emerged from the northern side of the grove carrying pistol in his hand and fired at the deceased. The weapon used and the manner in which attack was made and the injury was inflicted due to premeditation clearly established that appellant intended to cause the injury. Once it is established that the accused intentionally inflicted the injury, then the offense would be murder, if it is sufficient in the ordinary course of nature to cause death. We find substance in the contention of the Lawrence Council. For the appellant, the injury was on the inner part of left thigh, which is a not vital organ. Having regard to the facts and circumstances of the case, that the gunshot injury was caused in the inner part of left thigh, the sufficiency of injury to cause death must be proved and cannot be inferred from the fact that death has taken place. But the prosecution has not elicited from the doctors that the gunshot injury on the inner part of left thigh caused rupture of any important blood vessel, and it was sufficient in the ordinary course of nature to cause death. Keeping in view the situs and nature of injury, and in the absence of evidence elicited from the doctor that the said injury was sufficient in the ordinary course of nature to cause death, we are of the view that it is a fit case where a conviction of appellant under section 302 IPC should be under section 30
Here,
part 1.
this case is only the difference is that the part of the body was the left thigh. But here in this case it was on the head.
Yes.
Otherwise,
that was not in the vital part. This is in the vital part.
that is the difference between this.
But the
Factual difference.
and
No, that part is there.
Yes.
Sufficient in ordinary course of
That is
nature. So here, the Honorable Supreme Court has held that there cannot be any doubt in view of the evidence that the man has caused those injuries.
Yes.
But since the injuries are on the non-vital part of the body,
It could have been
and,
LC.
and of course it is not in, there is no opinion that is sufficient in ordinary course of so and so. So that was the consideration.
And death was due to that gunshot injury, for which
No, obviously,
Yes.
but they held
Uh,
that, you see,
yes.
even on the non-vital part of the body also, suppose there are some injury, it is held, somebody caught sear.
yes, ma'am.
Can you say that this portion is a vital part of the body? If it is cut here, cannot the death occur if the blood is not checked? It's vital because the vein, you do not know which particular vein is important. But the assailant might not be knowing, the injured might not be knowing, but fact remains that there is a vital part.
Yes.
So question is that ordinarily it is to be said that you have caused the injury. Vital part, we know that what are the, ordinarily it is said that, and so it depends upon factual scenario. So we find at least that the factual difference is that apart from that gone injury is there, but the part of the body is somehow different.
Yes.
In this present
Yes.
case, the part of the body is the head and chest,
Yes.
whereas in this case it was on the left thigh. What is the other one?
Other one is
2002.
yes, my lord. Here there is a tussle between two brothers, and the assaulted the deceased and caused 3 injuries.
Three injuries means that is described in paragraph number 11.
Yes, my lord.
Please read those injury first.
PW6.
Hmm.
The doctor who conducted postmortem of the dead body
Hmm.
at Erode Government Hospital noticed the following wounds on the body of the deceased. A 4 cm stitch wound on the right side chest, 4 cm below first wound in the backside of the wound. There was a 6 cm length stitch wound.
Hmm.
And in the left side of the stomach there was 15 cm stitch wound, vertical and horizontal like a T. A 1 cm length stitch wound between the right thick and the thigh and the genitals. There is a tear wound in a size of 4 into 1 into 4 cm on the left ear. A stab wound 3 cm.
Here there are some vital part of the body is there. So what is the weapon here in this present case? মানে এই যে কেস
stab wound হয়েছে
মানে ছুরি না কোন?
yes ছুরি নୁହଁ ତ ସେଟା କଣ
আচ্ছা কোন ହେଲା ତାପରେ ପଢି continue that PW5 who admitted
first he admitted, PW had examined him. PW5.
no are continue from that paragraph.
PW5 who admitted the deceased in the hospital also mentioned the same injuries. According to him, the stab wound of 3 cm to half can on the left of the abdomen corresponding to injury number 3 noted by PW6 exposed the fatty covering of the stomach and surgery was done to treat it. PW5 stated that even though women tam projected outside the stomach, there was no possibility of death if there was no projected outside, there was no injury inside the stomach. He further stated that if no internal organ was damaged from the second wound, namely stab wound of 4 cm, 2 cm into 4 cm on the center of the right chest, death cannot occur on account of that wound. He then stated that the lungs were situated beneath the second wound. So also with the regard to the sixth injury, namely stab wound on the right side of the chest of 4 cm into 2 cm, there was no possibility of death if no internal organ was damaged. The lungs were situated beneath the sixth wound also. He deposed that in the treatment chart giving the details of surgery done, there was no mention of any wound in the lungs, but there was mention of tear wound in the gallbladder. Looking at a medical officer, looking at
MO1,
MO1, sorry, MO1, he stated that the corners of the two sides of lens were not as sharp as knife. They were somewhat blunt. PW5 further stated that on account of oozing of extra from the colon, the wounds got infected and became septic. If it was not infected, there was no chance of his death. Coming back to the deposition of PW6, it a postmortem doctor. He found one internal examination of the inner chamber of stomach, 2 cm length stitch wound at the bend of the intestine. The gallbladder was inflamed and blood clot was seen. There were two tears, 2 cm into 1 cm size of the gallbladder. He also stated the death occurred as a result of onset of septicemia because of the pus and infection. PW6 further deposed that the wounds on the gallbladder were capable of causing death. He then stated in the course of examination that there was not much of blood loss on account of wounds in gallbladder. The gallbladder wound was possible without any damage to lungs. If a person fell down or got hit in the stomach with force or kicked by legs, his gallbladder can be injured. There was no tearing of liver due to the sixth wound, which was above the gallbladder. He then added that it cannot be said that death was certainly on account of stab wounds or in the gallbladder.
Yes.
Then comes.
Read 12.
Huh.
The question then is whether the offense falls under section 300 IPC or the appellant can be convicted for the lesser offense, a point which has not been discussed by the High Court. It raises the question whether the appellant had an intention to cause death or such bodily injury as was sufficient in the ordinary course of nature to cause death. It seems to us that on the facts disclosed in evidence, it is not safe to infer an intention to cause death. No doubt in the second dying declaration, PW 16, it was stated that the land dispute between him and the accused was the cause of the occurrence. But such bald and vague statement can
Bald and
କଣ
vague.
କଣ ପଢୁଛନ୍ତି ଆପଣ ଟିକେ ଧୈର୍ଯ୍ୟ ଧରି ପଢନ୍ତୁ।
statement cannot be taken note of. The wife of the deceased, namely PW1, who was treated as hostile witness, denied having made any statement to the police that the accused became envious after her husband purchased land for rupees 10,000 from one Thogan alias Palyanpan. No other evidence is available to establish the motive. The genesis of the incident, as brought out by the prosecution, is traceable to a petty quarrel which would have been sparked off by the admission given by the deceased for his alleged misbehavior in whistling. All of a sudden, he entered his house, picked up the weapon, and attacked the inflicted injuries on the deceased. Though he was in a position to cause instantaneous death of the victim by dealing fatal blows, he left the spot after being persuaded by his wife to rush to the scene of offense on hearing the cries. He even allowed the weapon to be taken out of his hands by his wife. He stopped at that point. On a consideration of the totality of the circumstances, it is difficult to impute the accused the intention to put an end to the life of the deceased. Nevertheless, intention to cause severe bodily injury has to be necessarily imputed to the appellant. But then the objective test, whether the injuries were sufficient in the ordinary course of nature to cause death, has to be satisfied to bring home the guilt of the accused under clause thirdly of section 300 IPC. It is here that the medical evidence assumes much importance. We have already referred to the substance of the evidence given by the two doctors, PW 5 and 6. The former who attended on him while in hospital and the latter who conducted postmortem of the body. 13. Though PW 5 broadly stated the injuries 1, 2, and 6 were serious enough to cause death, in cross-examination he made it clear that he was not aware of any internal injury in the body of the patient. He noticed fatty covering of the stomach protruding outside. He proceeded to say that if there was no injury inside the stomach, there was no possibility of death. So also with regard to injury 2 and 6, he stated that if there was no damage of internal organs, death would not occur on account of those external injuries. He further stated that there was no wound on the lungs. He then stated that the immediate cause of death was the infection on account of oozing of extra from the colon, and the wounds become septic thereby. His evidence viewed as a whole does not lead to a definite conclusion as to the sufficiency of injuries causing death in ordinary course. The evidence of Dr. PW6, who did postmortem, is also not categorical so as to form a definite opinion that the injuries inflicted on the deceased were sufficient in the ordinary course of nature to cause death. While reiterating the opinion of PW5 that death occurred by region of onset of septicemia because of pus and infection, he deposed that the wounds on the gallbladder of the deceased would be capable of causing death. At the same time, he stated in the cross-examination that it cannot be said with certainty that the wounds on the gallbladder would result in death. It may be noticed that the nature of wounds on the gallbladder was 2 tears. If the gallbladder was wounded on account of stabbing, normally one would find an inside wound there. That is why what he further said in the cross-examination assumes importance. He stated that gallbladder injury could occur if a person fell or got hit in the stomach with force and kicked by leg. The possibility of such contingency cannot be ruled out in the instant case. Moreover, PW6 did not notice much loss of blood on account of gallbladder injury. In these circumstances, a reasonable doubt arises whether the tear wounds on the gallbladder, which according to PW6 were capable of causing death, were sufficient in the ordinary course of nature to cause death. At the same time, the nature of injuries and the medical opinion unmistakably point to the fact that the bodily injury inflicted on the deceased were of such nature that they were likely to cause death. There can be no doubt the accused intended to cause and did cause the injuries. We are therefore of the view that the appellant is liable to punish under the first part of section 304 IPC. He is therefore convicted under 305.
Who has seen the assault from the beginning? PW4 panel. 4.
PW4.
Please read that portion. Let us see that.
Page 62.
Ah,
Para 3.
para 2 ta padhantu.
The accused was always suspecting the character of his wife. He was also suspecting his wife who had kept illicit relationship with one Londa Balaji of village Chidupudi. On the said Londa and the said Londa Balaji was a close friend of my son Upada Jagannath, the deceased. The occurrence took place on 30/3/2004 at about 9 p.m. in the front of my house at village Chidipudi. At that time, I was sitting on the front veranda of my house. At the relevant time, my son deceased Upada Jagannath was going to attend call of nature to a nearby tank. While my son was proceeding towards tank, at that time the accused Upada Kubanu suddenly appeared before him and gave a blow by means of a Dhanakuta Paharuni on the head of the deceased with force. As a result, my son fell down on the khari of Chandreya, having a serious bleeding injury on his head, and cried mortally. When my soul fell down on the knee of Chandreya, again accused gave another blow on his chest by means of that Dhanakuta Paharuni. My son, after sustaining injury, raised mortally, and hearing my cry myself, Madhya, Bhubensu, and Areswami pushed near to him. Thereafter, we all took my son to house Madhya. When we gave water, my son did not take the same. When we reached near my son, the accused fled away, leaving Dhanakuta Paharani at the spot.
So 2 blows have been given. The first blow is on the head. Second blow is on the chest, right? So what the doctor has stated. Please come to the doctor once again. PW6.
Page 71.
Lacerated wound present longitudinally over mid vertex. Size is so and so, skull deep. Okay. Contusion of size so and so, left frontotemporal area. Parallel bruises present obliquely over the abdomen, starting from right nipple extending so and so. Contusion multiply number of various sizes so and so, range from so and so. Right side face, right pectoral area, abated contusion of size so and so, placed vertically in the middle of the seam of the left tibia. On dissection, the following internal injuries found: diffuse hematoma involving almost whole the vortex also. Left parieto also was found depressed involving also. Coronal structure is found to be specific on the right side, corresponding to the external injury number 1. Linear fracture line, the distance of zones, subdural hematoma on the also, fracture of reefs also. The above injuries are antemortem, homicidal, 1 and 2 with the corresponding internal injuries caused by hard and blunt trauma or even flat here, while the injuries number 3 caused by lateral. Rest of the injuries will be possible due to friction of the body against the hard and blunt object or even by fall on this one. So this is that of the injury in the head and its complication thereof. So this what the doctor says about this 4 and 5, they are possible by fall or friction. 1, 2, that has been caused by perhaps one blow. That is because there are two blows. So
Yes.
1 and 2 are on the head. So that is one blow, and the other one, that is number 3. That
Yes.
was the blow which was given on the chest that has caused that injury. And he has examined the weapon of offense. Dhanakuta Pahurani se kouchi weapon of offense. Taku IO sent it for his opinion, and he opined that 1 and 2, including the corresponding internal injury and injury number 3, would be possible by such type of weapon. So, as such, there is no contradiction, or there is between the oral evidence and the medical evidence, right? So the only thing that is here is about doctor's opinion is not, and when the death occurred.
After 2 to 3 hours. When he was shifted to medical, on the way he was died.
Okay. What do you say, Mr. Tripathi? The background is that the appellant was suspecting that the friend of the accused was having illicit relationship.
That Londa Balaji was also examined, but he was not examined in the trial, Your Lordship, but his 161 probably recorded. That has been told by the IOPW 10. That the deceased also illicit relationship with that lady.
But doubting like that.
Anyway, there is a motive.
So there was the accused, the appellant was doubting it, and in that doubt, perhaps he assaulted. Now, 2 blows have been given, and he fled out.
Another decision is 2022 88 OCR Supreme Court. I have not zerox. And in that case, Bahi was used and blow was given on the head. There are all total 8 injuries, but other injuries are by fall or a friction. but the main blow was on the head,
Head,
and that was converted to 3042.
No. About this sufficient in ordinary course of that has been dealt with.
Is that
এটা ଟିକେ ভার করলো এই অনুপাত্রটা কোথায় এটা ওকে হয়নি
I have the Xerox.
Got it.
Dita. Okay.
type for 2005 so page number
Vision is there. I have brought
oh, 1451 madam কয়টা আমার গেল 2005 SCC criminal 1451 1451 ଶୀଘ୍ର କୁହ 15 ମିନିଟ୍ ପରେ ନହେଲେ ନେଇକିନା ଆସିବି ଯାଅ ତମେ ଯାଅ which is provided, which is called the government, and so which is considered so people returns level complete and the important principle of law science and is summed up. What is compulsory question? What often the accused could be said to have committed. The true test is to find out the intention or knowledge of the accused to implement. The intention of the knowledge of such as is visible was A to 4 of section 300 of the Indian Penal Code. Even though a single interest cost to illustrate A is bound hand and B comes facing a revolver and the head of the suit jail inside killing instantaneously. Here there will be no the intention of B in shooting A was to kill him. Only one interest cost. The case would go to B murder, falling under clause 1 of section 300 of Indian Code. Taking another instance, he sneaks into the bedroom is on an A, while the bedroom is given in bed. Letting him on the left chest of A, Stevie plunges his sword, left chest of A, and on side. He dies shortly thereafter. The injury to A was found to be sufficient in ordinary course of nature to cause. There may be no difficulty that B intentionally inflicted that particular injury found to be caused and that the said injury is objectively sufficient in ordinary of nature to cause. be likely, which is generally spoken, as an injury likely to cause death, and the case does not fall under clause 2, section 300 of the Anti-Bank. When the art is done, knowledge of faith is likely to increase, but without intention to state of an injury to life. It's fine. The difference between the parts of the 300 is that on the first part, crime of murder is first established, and the accused is given benefit of an exception of section 300 of the Indian Penal. While on the second part, crime of murder is never established at all. Therefore, for the purpose of holding the responsibility of the offense permissible under section 1, the accused need to bring the did not bring an annual exception. So, while life is probably is distinguished from more possible, and the chances of happening are even or greater than it's not happening. They say that the thing will probably happen. In reaching the has to place itself the situation of the content judge, whether the accused has the knowledge that by the act he was likely to cause death. The distinction between said so and so and the murder so and so has always been carefully defined by the judge and the system. internal several some but so say but we are to sufficient so the opinion appears to have been due to the because of this person in the damage from structure. In the absence of a clear medical evidence, we have examined the nature of the in internal disease as disclosed. The external and internal have come to become that it was positive fever resulting from within the resulting data. In the table has not damaged for our data. We say so is no clear medical data. Question is whether in this case of grievance in the case is covered by 300 party is that is to say whether the appellants committed the act intention of the bodily injury etc and the bodily injury was sufficient so check to death in versus to one so this court considered the facts and that the prosecution must be following facts is under 300 party. First, it was to establish right objective that in this present. Second, nature of injury dispute. There are purely objective investigation. Hardly it must be that there was intention to pick that particular that is to say that it was not accidental or unintentional or some kind of chance. And once these three elements are present, the inquiry proceeds to be four. It must be the type so specified three elements set down each sufficient to consider. So this part of the inquiry is purely objective and inferential and does not the intention of this argument. In this one, so the simple truth very far laws that general speaks of an intention cause body injury which is sufficient in ordinary person. Sufficiency is a high probability of death. The ordinary sufficient. When this exists, and death ensures, and the causing of such injury is intended, the offense is not. Sometimes the nature of weapon, sometimes part of the body increase score, and sometimes both are relevant. The determining factor is the intentional injury, which must be sufficient to state if the intended injury cannot be said to be sufficient to so that is to say the probability of death is not so high, the offense does not begin. But begin and to model on this. In the same journey, this court cautioned that this can be an authority on fact. This is to say it's a question of fact as whether that he said a particular to that is to say that some bad or such and so one ingredient that the injury which you are intended to cause will have sufficient faith in that culture that is obvious to that they were intended to cause we are sufficient in the nature to keeping in this principle nine then facts of this case will find offense to seven. There was no position of Swansha on the part of the found the parties dance with night Swansha happened itself on the small incident. Thereafter proceeded with their respective ways. It is not the case of the prosecution of the appellants who have hardly dealt with. Some of them have carrying patterns as is usual. There are the travels of that part of the state and have carried and not made any special preparation for PSO. Some others are just the fact of this one issue and assaulted it. it is known that they assaulted the deceased in such a manner that the deceased suffered several fractures. But the injury which caused the death of deceased is one suffered by him on account of the punching. We have convinced that this injury was not intended by the appellant of the injury suffered by the deceased on the liquor for the test accident. And therefore, that section 300 RD IPC is not addressed. Cannot be said that the appellant intended the injury which perhaps of fatal. There is no evidence to show that the other injury suffered by him was sufficient to cause death by him also. The question is under which provision of the IPC the appellants will be punished. Counsel for the appellants even if the case does not respond so it we fall under three part. We say that the appellants had no intention to cause death. They certainly knew such burdening was likely to cause the impact of submit that even if the appellants may not be guilty of the charge, so they certainly can't be guilty of some. I mean, consider 304 part. This one is certain. He held she they said that the intention is taking it 304 part one.
And-
And
and
see 138 of 2005. This is item number कितना?
18.
The appellant Uppoda Ubenu faced trial in the court of Learned Ad hoc Additional Session Judge Fast Track, Barhampur, in Sessions Case number 9/2004, bracket लिखी दियो SC number 374/04 GDC, bracket ends, for offence punishable under section 302 of the Indian Penal Code, on the accusation that on 30/3/2004 at about 9 p.m. in village Donda, bracket Chidi Pudi, CHIDI Pudi, he committed murder by intentionally causing the death of Uppudu Jagannath, bracketary hereafter the deceased. That is the only charge, na? The London Trial Court made impugn judgment and order dated 16th August 2005 found the appellant guilty of the offence charged and sentenced him to undergo imprisonment for life and to pay a fine of rupees 5,000, in default to undergo RI for 6 months more. Stop. Next para. The prosecution case as per the first information report lodged by Uppada Pandeya, bracketary PW4, before the officer in charge of Jaroda Police Station on 31/3/2004, in short, is that the appellant used to work outside the state and when he returned to the village, returned to his village, he suspected his wife was having illicit relationship with the friend of the son of the informant, the friend of the deceased, who is the friend of the deceased, namely Landa Balaji. The deceased was the son of the informant. It is further stated that on 30/3/2004, in the evening hours, the appellant created disturbance with the deceased and also slapped him for 4 to 5 times. But the deceased didn't respond. And at about 9 o'clock in the night, when the deceased was going to the village, towards the village pond for attending call of nature, all on a sudden, the appellant came out of his house with one, এটা ইনভার্টেড কমা ভিতরে লিখে দেব, ধান্য কুটা পাহুরানী, তার এটা দেখিয়ে নি লিখলাম, and assaulted on the head of the deceased, as a result of which the deceased sustained a bleeding injury and fell down in front of the house of Uppada Chandraya. The appellant then dealt another blow on the chest of the deceased with the weapon which he was holding. Stop. The deceased shouted, "Marigali, Marigali," inverted comma ভিতরে রাখবো, single inverted comma. And when the co-villagers Uppada Madheya bracket PW1 D Swami bracket PW5 and another namely Uppada Bhubuni rushed to the along with the informant PW4 rushed towards the spot, comma, they obstructed the appellant but the appellant fled away from the spot. They tried to obstruct the appellant, but the appellant fled away from the spot, leaving the weapon of offense. The deceased was shifted to Jayantpur for treatment in a tractor, and from that place he was shifted towards Ichhapur in a tempo, but on the way near Jorada Junction, the deceased died. The informant bracket PW4 brought the dead body of the deceased to the village, and since it was late night, comma, in the morning he lost the first information report. Sopara. On receipt of the written report from PW4, comma, the officer in charge of Jarada police station Nilakantha Prasad Patro bracket PW8 registered Jarada PS case number 27 dated 31/3/2004 under section 302 of the Indian Penal Code, and he himself took up investigation of the case. During course of investigation, comma, he examined the informant bracket PW4, comma, visited the spot, comma, prepared the spot map bracket exhibit 8, and seized bloodstained earth and sample earth from the spot as per seizure list Exhibit 1. He held inquest over the dead body in presence of witnesses and prepared the inquest report marked as Exhibit 3. He also seized Dhanakuta Pohurani, weapon of offense, on production of the informant PW4 at the spot as per seizure list Exhibit 2. The dead body was sent to MKCG Medical College and Hospital, Barhampur for post-mortem examination. The IO PW8 examined other witnesses of at village Chidipudi on 1/4/2004. He arrested the appellant and forwarded him to court. He seized the wearing apparels of the appellant see the wearing apparels of so on. Oh, deceased data. He seized the wearing apparels of the deceased on the production of the constable as per seizure list Exhibit 9. He received the post-mortem examination report from the superintendent MKCG Medical College Hospital and then made a query to the medical officer who conducted autopsy over the dead body of the deceased to ascertain whether the injuries detected on the dead body could be possible by the seized weapon of offense, that is Dhanakuta Pohuruni. And he also received the query report from the medical officer marked as Exhibit 7. On the prayer of the investigating officer, PW8, the seized articles, that is bloodstained earth, sample earth, wearing apparels of the deceased, were sent to RFSL Barhampur for chemical examination. And on 24/6/2004, PW8 handed over the charge of investigation to his successor, PW7, BCH Tripathi, PW7, na? PCH, not BCH, Pratap Chandra Tripathi लिख दियो, ना पूरा ना लिख दियो, PW7, who on completion of investigation submitted charge sheet under section 302 of the Indian Penal Code against the appellant. The defense plea is one of denial, and it is stated that he has been falsely implicated in the case. In order to prove its case, the prosecution examined 8 witnesses সেটা লিখি দেবে ଆପଣ তারপরে material objects doc exhibits গুলো লিখি দেবে The defense has not examined any witness nor proved any documentary evidence. The Lenin trial court, after analyzing the oral as well as documentary evidence on record, came to hold that the death of the deceased was homicidal in nature. The Lenin trial court, after analyzing the evidence of PW 1, 3, 4, and 5, who are the eyewitnesses to the occurrence, also the medical evidence, came to hold that the medical evidence fully corroborates the ocular evidence of PWs 1, 3, 4, and 5. The Lenin trial court further held that on a close scrutiny of the evidence of PWs 1, 3, 4, and 5, their evidence was found to be clear, consistent, and trustworthy. And from their evidence, he came to the conclusion that the appellant is the sole author of the crime. The Lenin trial court further held that from the direct evidence of the eyewitnesses coupled with the medical evidence, it has been established beyond all reasonable doubt that it is the appellant who caused the injuries on the vital parts of the body of the deceased. And when the deceased died on account of the above injuries, on account of the injuries inflicted on him, as per the post-mortem report, it must be held that the prosecution has succeeded in establishing the fact that the deceased died a homicidal death and the appellant intentionally caused the injuries on the vital part of the body of the deceased. And therefore, it was held that the prosecution has succeeded in bringing home the charge under Section 302 of the Indian Penal Code against the appellant beyond all shadow of reasonable doubt. and found the appellant guilty of the offense charged. Mr. Pulakesh Mahanti, Lenin, counsel for the appellant, contended that the evidence of the witnesses are not consistent and there is delay in lodging the first information report, and the doctor who conducted postmortem examination has not stated that any particular injury or the cumulative effect of all the injuries noticed by him were sufficient in ordinary course of nature to cause death, and therefore the Lennon trial court was not justified in convicting the appellant under section 302 of the Indian Penal Code. And if the prosecution case is at all believed, then the case would come within the purview of section 304 part 1 of the Indian Penal Code. He placed reliance in the cases of so and so, so and so. This one would have been. Mr. Rajesh Tripathi, London Additional Standing Counsel, on the other hand, supported the impugned judgment and submitted that there is no such delay in lodging the first information report, and the occurrence in question took place on 30/3/2004 at about 9 p.m. and the deceased was shifted to the hospital, but on the way when he expired, since it was late in the night, he was brought back to the village, and on the next day, early morning, the first information report was lost. And the distance of the police station from the place of occurrence was 20 kilometers as per the formal FIR, and therefore it cannot be said that there was any delay in lodging the first information report, which gave opportunity to the prosecution to fabricate a version. The Land Council for the state further submitted that the presence of the eyewitnesses at the scene of occurrence were the co-villagers are very natural, and all of them have consistently stated how the assault was made on the deceased. And the doctor's version corroborates the ocular version, and the vital part of the body where the assault has taken place also indicates that the intention of the appellant was nothing else than to commit murder of the deceased. And when the doctor has verifying the weapon of offense has opined that the injuries caused to the deceased were possible by the weapon of offense, it cannot be said that there is any illegality or infirmity in the impugned judgment, and therefore the appeal should be dismissed. Adverting to the contention raised by the Land Council for the respective parties, let us first examine the evidence of the doctor to verify whether the finding arrived at by the London trial court that the prosecution has established that the deceased met with a homicidal death is correct or not. The PW6 was the assistant professor in FMT department, MKCG Medical Hospital, Cuttack, and he has stated that on 31/3/2004 conducted post-mortem examination for the dead body of the deceased, and he noticed the following external injuries. Quote kar dewe. On dissection, he noted the following internal injuries. Quote kar dewe. The doctor has further stated, quote kar dewe, paragraph number 4. The there is no challenge to the evidence of the doctor in the cross examination, and the learned counsel for the appellant has also not challenged that the death of the deceased was homicidal in nature. After going through the evidence of the doctor, the inquest report, the post-mortem report finding, we are of the humble view that the finding arrived at by the London trial court that the deceased met with a homicidal death is quite justified. Now coming to the evidence of the eyewitnesses, it appears that PW4 Uppada Pandya is a witness who has seen the occurrence right from the beginning, and he is none else than the father of the deceased. He has stated that the appellant was suspecting the character of his wife, and that his wife had kept illicit relationship with one Ronda Balaji of village Chidipudi, who happened to be the close friend of the deceased. The witness has further stated that on 30/3/2004 at about 9 p.m. the occurrence took place in front of the house of his house and at that point of time he was sitting in front veranda of his house, and the deceased was going to attend the call of nature to a nearby tank. And while the deceased was so proceeding, the appellant appeared all on a sudden before him and gave a blow on his head by means of Dhanakuta Pahurani with the force, as a result of which the deceased fell down on the honeycomb.
ଧାନ କୁଟନ୍ତି ଖଣି କୁହନ୍ତି
Honda?
ଧାନ ଯୋଉଠି କୁଟନ୍ତି ସେ ଯୋଉ ଜାଗାରେ ଖଣି କୁହନ୍ତି ଚାଉଳ
Acha, acha. On the ground, on the ground, acha, on the thrashing of one Chandriya, having sustaining bleeding injury on the head, and shouted and cried Marigali. And when the deceased fell down, the appellant dealt another blow on the chest of the deceased with that Dhankuta Pahurani, and the deceased sustained further injury and raised Marigali, Marigali, and hearing his cry, Madheya bracketed PW1, Araswamy bracketed PW5, and one Bhubnesu rushed to the spot. The PW4 further stated that all of them took the deceased to the house of Madheya. They gave water to the deceased, but he didn't take the same. Then when they arrived at the appellant fled away, leaving the Dhanakuta Purani. Then they shifted the deceased to Jayantipur by means of a tractor belonging to one Tamaya of their village. And from Jayantipur, while they were taking the deceased to Ichhapur hospital by means of an auto rickshaw at Jorada Junction, the deceased expired, for which they returned to their village along with the dead body and kept the dead body near the village pool. And on the next day, before police, the matter uh, was reported. In the cross-examination, it is the PW4 has stated that PW2 Padhi Babu scribed the first information report. He admitted that PW1 is his cousin brother and PW3 is the son of PW1. However, he has disputed the suggestion of the defense that PW5 is the son of his sister. He further stated that there was no electric light at the spot from an electric pole, but a 200-watt bulb was burning at the outer veranda of the house of PW1 near the spot. A question put by the London Defense Counsel, PW4 has stated that he could recognize the appellant at the time of occurrence by the help of moonlight as well as the electric light focus which was coming from the outer veranda of PW1. About the knowledge of the illicit relationship between the wife of the deceased with Londa Balaji, the PW4 stated that it is the appellant who told him that his wife had kept illicit relationship with Londa Balaji prior to the incident. He further stated that when the appellant got the second blow on the chest of the appellant dealt the second blow on the chest of the deceased by means of Dhanput Paurani. At that time, he was proceeding towards the spot to save his son, and simultaneously, PW1, PW5, and Bhuvnesh reached at the spot. He has denied the suggestion put forth by the defense counsel that his eyesight is defective, and he specifically stated that he didn't use any spectacle. We find that the defense has failed to demolish the evidence of PW1 in any manner. He has stood the cross uh, taste of cross examination well, and from the evidence, it appears that he has seen the occurrence right from the beginning till end. The identity of the appellant cannot be disputed, particularly in view of the fact that they were co-villagers, and as stated by the PW4 that it was a moonlit night and there was also electric light coming from the outer veranda of PW1. Therefore, we are of the humble view that the evidence of PW4, who is none else than the father of the victim, a father of the deceased, and is not who is not supposed to leave the real culprit and implicate somebody falsely, is found to be consistent and credit worthy. Coming to the evidence of the other eyewitnesses, that is PW1, it appears that he has stated that on the date of occurrence at about 9 p.m. he heard marigali sound near the house of Chandreya and found a gathering. And then he went there and found that the appellant was standing holding Dhanakuta Purani, and the appellant dealt a blow on the chest of the deceased, and prior to that the deceased had already sustained bleeding injury on the head. PW1 further stated that he snatched the Dhankuta Purani from the hands of the appellant and gave the same to Pandya, bracket to PW4. And immediately the appellant left the spot. PW1 has further stated as to how the deceased was shifted to the first to Jayantipur in a tractor, and then how they tried to shift him to Ichhapur hospital by an auto rickshaw, but the deceased expired, and for which they brought the dead body of the deceased back to the village. The witness was cross-examined at length, and in the cross-examination he has specifically stated that he had seen while the appellant gave one blow on the chest of the deceased by means of pahuruni, by raising the pahuruni on its head height, and he saw the assault of the appellant to the deceased at a distance of 10 cubits away. Uh, uh, from away from the place where he was standing. And he further stated that hearing marigali sound from the spot, he came to the came from his house and rushed toward this spot. The evidence of the witness, like PW1, has not been shaken at all in the cross-examination, and he his statement, his evidence that he saw the second blow given to the deceased by the appellant on the chest by the Purani corroborates the version of PW4 that on hearing marigali sound, PW1 arrived at the scene of occurrence. PW3 is another eyewitness to the occurrence, and he has stated that on the occurrence day in the night, he was witnessing television in his house And at that time, PW4 shouted, inverted comma, Mo puo marigala, Dithora, inverted commas, and hearing such sound, he immediately came out of his house and found the deceased was lying down in the uh, thrashing floor of Chandriya, having sustaining bleeding injury on the head. And he could see the uh, deceased with the help of electric light which was burning on the outer veranda of his house. PW3 further stated that the appellant dealt a blow on the chest of the deceased by means of Dhankuta Paurani, and he has also stated about the presence of other eyewitnesses like PW1, PW4, and PW5 at the spot. He specifically stated that the appellant fled away from the spot, throwing the Dhankuta Paurani at the spot. Like the witnesses PW1 and PW4, PW3 has also stated about shifting of the deceased in a tractor first to Jayantipur, and then attempts were made to shift him to Ichhapur in an auto rickshaw, but on the way he succumbed to the injuries, for which he was brought back to the dead body was brought back to the village. The In the cross examination, the London Defense Council has asked about the relationship, his relationship with PW4, and he has admitted that PW4 was his elder cousin brother of his father, and the deceased in that way was his cousin brother. The no specific question to doubt his credibility on the assault part has been asked in the cross examination by the London Defense Council, and questions have been put relating to the shifting of the dead body, shifting of the injured from the place of occurrence, from the spot, and to first to Jayantipur, and then to Ichhapur, and the witness have specifically stated that the dead body was shifted on the trolley of the tractor, and uh, about 20 to 30 persons went along with in the on the said tractor uh, in that night. And he stated that the distance between Jayantipur to village Chidipuri would be 2 to 3 miles, and there was no pitch road connecting Jayantipur to the village. Nothing substantial has been elicited in the cross-examination to doubt the version of PW3. PW5 is another eyewitness to the occurrence, and he has stated that after taking dinner, while he was coming outside from his relative's house, from his residential house, he heard halla and found some persons gathered in front of the house of Upudu Chandraya, a bracket re PW Upudu Chandraya was the examiner. And when he went towards the spot, he found that the appellant dealt a blow by means of a Dhanakuta Porani on the head of the deceased, as a result of which the deceased fell down. And then again the appellant dealt another blow by means of that weapon on the right side of the right side of the and then fled away from the spot. He further stated that he could identify the appellant by help of the burning electric light. He has also stated about the shifting of the deceased first to Jayantipur and then from Jayantipur to Ichhapur, which, like the statements of the other eyewitnesses, no questions have been specifically put on by the learned defense counsel in the cross-examination about the assault part, but questions have been put about the weapon of offense and the PW5 has stated that he had not seen whether the weapon of offense was taken by anybody or that was uh, when they shifted the dead body to the outer veranda of PW4. Therefore, the the version of all these four eyewitnesses to the occurrence are found to be consistent, and since the evidence has come on record that electric light was available at the spot, so also it was a moonlit night. Therefore, the identity of the appellant cannot be disputed, more particularly when he is a co-villager of all the eyewitnesses. From the evidence of the eyewitnesses, it is established that on the date of occurrence, while the deceased was going to attend call of nature from his house, the appellant all on a sudden came out with a Dhanakuta Pohuruni and first dealt a blow on the head of the deceased, and after the deceased fell down uh, on the uh, thrashing floor of one Chandriya, the second blow was given on his chest. Uh, and then the appellant, leaving the weapon of offense at the place, fled away. If at this stage we see the evidence of the doctor bracket PW6, it would appear that the weapon of offense was sent to him by the investigating officer for seeking his opinion about the possibility of the injury caused on the deceased by such weapon, and the doctor, after examining the weapon of offense, specifically stated that the report, query report for them. So that is marked as Exhibit 7. The Therefore, the ocular evidence of the four eyewitnesses gets sufficient corroboration from the medical evidence adduced by PW6. Now, coming to the question of the submission made by the learned counsel for the petitioner, appellant, as to whether the offense would be one under section 302 or 304 part 1 of the Indian Penal Code. At first, we want to discuss the citations placed by the respective parties. In case of so-and-so, এই যে জাতীয় citation ମୁଁ ତାଙ୍କୁ କରିଦେବି relevant paragraphs ଗୁଡାକ ଆପଣ quote କରିଦେବେ, including এই ଯୋଉ decision ଟା এটা এটা କଣ report ହେଇଛି ନା ନାଇଁ, ଏଇଟା same decision ଟା ଆଉ ଗୋଟେ ଏଇଟା ସେମାନଙ୍କ citation ଟା ଆଗେ ଲେଖିଦେବେ, ଏଇ ଯୋଉ ଚାରିଟା decision ଦେଇଛନ୍ତି ସେମାନେ ଆଉ in case of ସେଟା ସରିଗଲା ପରେ ଏଇଟା ଲେଖିବେ in case of ANBAGAN versus state represented by Inspector of Police अच्छा AR 2023 Supreme Court AIR 2023 Supreme Court 3660 ହେଲା तारे paragraph टा एठी अछि बयटा आनी देखिए paragraph टा सेठी केते थिबो कोन थिबो तार सब डिस्कशन पर कंक्लूजन आइले 40 46 हाँ paragraph 60 अछि माने मनुपात्र पेज हैला तो सेठी कोन कोन थिबो देखि देबे सेटा स्टार्ट होउची few important principle of law हैला आपरे एडिशन टा कोट करंतु in case of सेटा होउची Human Singh and others versus state of MP reported in 2005 Supreme Court cases 1451. Hala? It is held as follows. The paragraph number 6 रो relevant paragraph को quote करिवे मु गोल बुलेई दउछि हला then 6 and 7 then 8 quote कर दियंतु 9 भी quote कर दियंतु हला 9 जाए quote कर 10 9 10 10 पर्यंत quote कर दियंतु हला the Learned Counsel for the appellant is right that the doctor has not opined either any individual injury or the injuries combined effect of the injuries noticed by him were sufficient in ordinary course of nature to cause death. Though the doctor has noticed as many as 5 external injuries, but he has clarified that the injuries number 4 and 5 wait, 4 and 5 ବିଷୟରେ କଣ କହିଲା ପରା ନା 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 ଏଇଟା ଅଛି 4 5 ଟା ନୁହଁ ସେ ଯୋଉଟା ଅଛି ହଁ ସେଗୁଡା କର the rest of the injury that injuries number 4 and 5 could be possible due to friction of the body surface against hard and blunt swan. So injuries number 1 and 2 thus possible by the blow which was given to by the on the head, and injury number 3 is possible by the blow which was given on the chest by the weapon of offense. ब्रैकेट लिख दियंतु वेपन ऑफ ऑफेंस टा होची MO1 कर देबे हां MO1 सेटा रिपीट करिवेन सबुडी धान कोठा पौराणी सेठी गोटे जगह लिखि देला परे तापरे सेटा MO1 करि चले taking into account the background of the case and the manner in which the occurrence has taken place and the postmortem report finding, and particularly when the doctor has not found any of the injuries or the cumulative effect of the injuries are sufficient in ordinary course of nature, we are of the humble view that the case would not fall within the ambit of murder as mentioned in section 300 of the Indian Penal Code, but it would come within culpable homicide not amounting to murder. And since the intention of the by the place of the body parts on which the assault was made indicates the intention of the appellant, we are of the view that the case would squarely fall within the ambit of section 304 part 1 of the Indian Penal Code. Accordingly, the conviction of the appellant is under section 302 is set aside. Instead, he is convicted under section 304 part 1 of the Indian Penal Code and sentenced to RI for 10 years. It is stated by the London Council for the appellant, that he was taken into a trial court record of the हाँ नहीं खाली हम कर देगी छाड़ दो बट ये टू बेर लेवल लेवल बाकी से the special report এটা বলা না। The appellant was taken into judicial custody on 1/4/2004 টিকে লিখে দিলাম করতেছে 1/4/2004 तो ट्रायल कोर्ट रे जा जणा पड़छि बेल नथिला ना and he was never released on bail during trial and 2005 ର appeal ହେଲା bail ଏଠୁ କେତେ order ହେଲା କେବେ
19/5/10
1905
2010 ତାପରେ ଗୋଟେ
ଦେଖିଲେ।
ମଡିଫିକେସନ ହେଇଥିଲା
ବାହାର ନଥିଲା ତାପରେ ବାହାରିଲା କେବେ ଆଁ 22/9/2010 କେମିତି ଜାଣିଲ
ନାଇଁ ମଡିଫିକେସନ
modification वो जो दे ही पारलानी comply and during pendency of the bail application of criminal appeal though he was granted bail by this court as per order dated 19/5/2010 but the appellant but the said condition was modified on 22/9/2010 whereafter the appellant has been released on bail से केबे जाइथियो कंट्रोल therefore if the appellant has not served the sentence केबे जाइथियो देकिन की भी जानियो if the appellant has if the appellant has not served the sentence imposed by us today the non-bailable warrant of arrest he shall surrender forthwith before the London trial court within a period of 2 weeks within a period of 15 days from today, failing which the London trial court shall take appropriate steps for his arrest to serve out the remaining part of the sentence, if any. With the jail criminal appeal is partly allowed. ଆପଣ amicus curiae appointment ହେଇଥିଲା ନା ମାନେ legal aid କରିଥିଲେ ଆପଣ ନା appellant କରିଥିଲା
appellant କରିଥିଲା
appellant କରିଥିଲା
notice ଗଲା
ନାଇଁ ନାଇଁ ସିଏ ଫାଇଲ କରିଥିଲେ ଆମେ amicus curiae ଆମେ କରିଥିଲେ ଇଏ ସେଇ ସେ ଆପଣ ନିଜେ ଫାଇଲ କରିଥିଲେ ଆଉ ଠିକ ଅଛି but note of appreciation day
MKC medical college କଟକ
ନାଇଁ sir, no.
ନାଇଁ ସେ କରିଦେବ
Correction ହବ।
ସେମିତି ମାନେ
No. We are conscious of that.
ଏଗୁଡା ଇଏ ମିଷ୍ଟର ତ୍ରିପାଠୀ ଆପଣ ଗୋଟିଏ ଡିସିସନ ଦେଇଥିଲେ ନା କୋଉ ଡିସିସନ ଟା ହେଟା
2022
ଶୁଣ ଏଗୁଡାକ ଏ ସବୁ ତକ ଡିସିସନ ସିଏ ଦେଇଛନ୍ତି ହେଲା appellant ଦେଇଛନ୍ତି ଖାଲି ସେ ଗୋଟିଏ ଡିସିସନ ତାଙ୍କ ଡିସିସନ ଟା ବାହାର କରିବେ ଏଇଟା ମୁଁ ଲେଖି ଦଉଛି ଆଉ ଆଜି ଯୋଉ ଦିଟା ଡିସିସନ ହେଲା ଏଇଟା appellant ଲେଖିଦେଲି ହେଲା ଏଇଟା ମଧ୍ୟ ଆପଣ କୋଉ ଡିସିସନ ଟା ଦେଇଥିଲେ
State of Uttar Pradesh versus Joy Datta and another 2022
ଏଇଟା appellant ଅଛି ଏଗୁଡା ସବୁ appellant ଏଇଟା ବି appellant ହେଲା ଏଗୁଡାକ ହଉଛି state ର ହେଲା ୟାକୁ ଛାଡିକି ଆମେ ଦିଟା ଡିସିସନ ଆଉ ଦେଲୁ ଗୋଟେ ଏଇଟା ଆଉ ଗୋଟେ ହେଲା ଏଇ ଆୟାଟା ଆଉ ବହିଟା ଆଉ ହେଲା ନିଅନ୍ତୁ ଆଉ କିଛି ପାଠ ଅଛି କଣ
ନାଇଁ ଗୋଟେ ପାଠାଟେ ଅଛି ବୋଧେ।
yes Mr. Misra
I may be excused not to be in dress. Yesterday evening, my associate's mother-in-law got heart attack. She was taken to hospital and finally she succumbed to death late night. Mr. Vishal took him to Sarvodar for cremation. Keys of the office are with him. The original evidence on affidavit, my dress are all in the office. So we have applied for time to take it, the matter on Monday.
Mr. Kanungo
Copy has been given.
Taruni Mishra's presence is not necessary. We are just to cross-examine the witness.
No,
Every time-
original affidavit, evidence on affidavit is not available.
My lord,
That is most.
he could have taken it from. I understand, my lord, sad predicament of Mr. Taruni Mishra, my lords. But this, my lords, every time something or the other, my lords, they're going on taking time. My lords.
now let us take up, let us not create any unpleasant situation. Let us take it on Monday. So Monday,
Mr. Agarwal has some personal difficulty.
Tuesday will take up.
My lord, the other affidavits, let them give copies to us.
Yes,
you
by
give
that
the
time.
By Sunday and not otherwise they will give it at Monday 9 o'clock in
No,
the night.
no,
This
no,
time
no.
also 8:30 in the night they gave us the
This time
affidavit
we
in
have to-
chief.
Please pass on that what application they have given. But your client should pay something to the High Court Bar Association.
Cost.
Yes.
No.
IA number so and so. This is an application seeking for adjournment filed by the petitioner. After hearing Mr. Vidyadhar Misra, land senior advocate, and Mr. Milan Kanungo, and senior advocate, so also Mr. Agwal, and going through the arguments taken in the interim application, I am inclined to adjourn the hearing of the case on consensus of all the parties to 17th of October 2023, subject to payment of cost of rupees 10,000. The High Court Bar Welfare Bar Welfare Association so and so the deposit has to be, the receipt has to be produced by the next date. So, yeah.
The affidavits may be
Time?
given to us
The
by Sunday.
Land and Council for the respondent submits that the evidence affidavit of one कौन था ना जहाँ देखते
Santosh Lenka.
Santosh Lenka
Santosh Lanka
has already been furnished to the Land and Council for the election petitioner, and he will supply two more affidavits. No? Two more affidavits. That is of. Can you tell the names?
Prashant Kumar Mahanti advocate.
Prashant Kumar Mahanti advocate.
And Surya Patra chartered accountant.
And one Surya Patra chartered accountant. Surya Mahapatra chartered accountant. Who are to be also examined on behalf of the respondent to the Land and Council for the election petitioner by केबे लिखिबी अपन देबे रविवार दिन भीतर दे दोनांती से मंगलवार जेरा करियो ना मंगलवार जणकू करिवे अपन मंगलवार से जो आकु नहीं आसंती
जनकर पाई जाइछंती आउ दुई जनकर दबु
तो अपन नहीं आसुनांती तीन जन जाकू नहीं आसन से सार देबे को
सेई तीन जन जाकू भी we are trying to bring them physically also.
ताल ठीक अछि ताल से दिन आसीबे कोन 17th if all the witness examination cross examination is over on that day, it's well and good. Otherwise it will be kept to 19th and it will be concluded 18th it will be concluded on that day. Okay, तो ना गुडा के लिखिले तो प्रथम नाटा कोन लिखिले जार देइछे
Santosh Kumar Lenka
in our advocate, and two more witnesses नाको ना हला कोन
Prashant Kumar Mahanti advocate and Surya Kumar Mahapatra chartered accountant.
हला. Okay, all right.
By Sunday,
by Sunday. Acha, by 15th of affidavit the affidavits to be furnished to the Land and Council for the election petitioner by 15th October 2023 evening hours for those. ता भीतर अपन दे देबे
ताले सॉफ्ट कॉपी दे दे.
हां चलो. Okay.
May I pardon, my lord?
Yeah.
What one modification, my lord?
conviction.
Conviction, my lord. Interim order is going to be expired. I will pardon to submit my lord. Criminal Office 1215 of 2022. I is pending. I forget.
Yeah.
Lord, I pardon to make a mention from the weekly list, my lord, item 99 leftover matter orders, my lord. Here, three petitions in 99. There are three anticipatory bills are pending, which is accidentally skipped out from the original list, my lord. And on my mention, it came to the list. It was in the below. Court has already been released on bail, my lord.
अभी काई मेंशन कर जे मु पूरा 60 केते पर्यंत जाईची तो सीरियली गले आपनकर पडिबो काई मेंशन करचंदी आपण 90 केते पर
99
हां अपेक्षा करनांती
गुरुवार छुट्टी टा हिजो गुरुवार दिन गुरु शुक्र दिन
नहले कमिंग वीक रे उपरु आसीबो कोन असुविधा होची जो पर्यंत सरीनी आपण नंबर देइथिले काली आ काल देइ नथिले काल जो माने जो नंबर उडा को दिया हिची से उडा को प्रथमे डका जीवो आपण आपनकर मैटर आसीबो 99 ऑल राइट आपण मैटर आसीबो जदी आज टाइम हुए निया जीवो नचे नेक्स्ट वीक रे निया जीवो हला
Yes. With item number 38 and 39 arising out of one case, Milord. You are only, Milord, one direction for status of the trial because I am praying for interim bail, Milord.
38
and 39, Milord.
କାଲି ପଢିନଥିଲା କି?
କାଲି ମୁଁ ଆଜି ମେନସନ କରିପାରିନଥିଲି। କଷ୍ଟଡି 38 ରେ ହେଲା ମିଲର 24 to 2020
38, 39 status report called for କରିଦିଅନ୍ତୁ from the concerned court, and it will come after Puja holidays. Yes.
oblige.
Beg your pardon, my lords. Criminal revision matter, my lords. 239 discharge petition was rejected. Vigilance is of the opposite party, my lords. The learned lower court below has fixed 18th of this month for framing of charge. Lordship, may kindly take it up.
No, sorry. Now only bail matters will be taken up next week. No more matter. Yes.
Modification order tied.
Dion.
CRLA fresh admission.
Item number 225 on weekly list. If possible,
No, have you given that number?
I have informed the CBI matter, not state one.
Okay, we'll see that. Call the matters.
The passport medical ground report now. Report. Next week item 10 and 15.
So ଯେତିକି ରହିବ next week ତ ରହିବ। जो ବର୍ତ୍ତମାନ ଯୋଉଡାକ ଆପଣ ନମ୍ବର ଦେଇଛନ୍ତି ସେଇ ଅନୁଯାୟୀ ଡାକନ୍ତୁ। ହଁ ସପ୍ଲିମେଣ୍ଟାରୀ ଟା ଆଗେ ଡାକି ଦିଅନ୍ତୁ ତାପରେ ଏଇଟା ଡାକିଦେବ।
Supplementary list item number 2.
एटा एक्सटेंशन ऑफ टाइम पे अछि करदेबे टाइम दे देबे जहाँ टाइम मागिछंती 3 मध्य से 4 से 5 भी सेम थिंग 6 भी सेम थिंग is now equal item number 7.
Item number 7.
Actually, item number 7. I have received the deposition copies. I'll serve it. Let it come after this.
Miss Pratyusha Naidu, Land Council, appearing for the petitioner, submits that he has received the certified copy of deposition of the witnesses examined so far in the trial court, and he will supply the same to the Land Council for the state.
I'll by Monday. I'll file.
By Monday, and will file a set of deposition for the court, and further submits that the matter may be taken up after ensuing Puja holidays. List this matter after Puja holidays. Yes.
Oblige.
Weekly list item number 46.
Please, Your Lordship. Milord, sir.
Is it the first application, Mr.
No, Milords. Earlier the application, there was a rejection in 2021. That order has been attached. There, Your Lordship directed after examination of 2 witnesses, namely B. Santosh, Tarini Chandra Mahanti and Niranjan Pradhan. Though I am in custody since 12/12/2019, out of 34 witnesses, only 9 witnesses have been examined. I have annexed those depositions. But those 2 witnesses are not turning up and the case is remaining as such. I am since December 2019, I am in custody.
No, this is coming for the first time. This particular application is coming for the first time.
Again.
So you mean to say, Mr. Sarangi, that several steps were taken by the Lanen trial court to summon those 2 witnesses?
Yes, they are not coming. 9 witnesses examined. I have annexed those documents.
No, it's all right. So you produce those 2 witnesses on the next date. Heard Mr. Devasi Sarangi, Land Council, appearing for the petitioner, and Land Council for the state. The Land Council for the petitioner submitted that in the trial court, out of 34 charge sheet witnesses, 9 witnesses have already been examined, and he has received the copies of deposition of those witnesses.
They have been annexed
and handed over to the Land Council for the state. Mr. Das, ଆପଣ ଦେଇ ଦେଇଛନ୍ତି ନଅଟା
Annex ଦେଇଛି।
however he submits that when the petitioner earlier approached this court for bail in BLAPL number 2995 of 2020 as per order dated 25/1/2021, while rejecting the bail application, the petitioner was given liberty to renew the prayer for bail after examination of eyewitnesses Tarini Chandra Mahanti and Niranjan Pradhan, and those two witnesses are not appearing before the Lennon trial court in spite of repeated summons. In view of such submission made by the Lennon counsel for the petitioner, let the inspector in charge of Parampur GRPS appear before the Lennon trial court, that is Lennon First Additional Session Judge Berhampur Ganjam, in ST case number 21 of 2021 on or before 19th of October 2023, and receive summons in respect of the aforesaid two eyewitnesses and ensure their attendance in court on the date fixed. List this matter on such and such date. If those two eyewitnesses are examined, Lennon counsel for the petitioner shall produce the certified copy of their deposition on the next date, giving copies to the Lennon counsel for the state. Free copy of the order be handed over to the Land Council for the state. Yes. এটা কেতে নম্বর গলা?
4-6 madam.
Item number 52.
52.
More than 3 years, 11 months, my lord.
Is it first application or
No, my lord, it is third application. My lord, the last
what is the date of custody you said?
custody, my lord, 14/11/2019.
Address verification by ଯାଇଥିଲା. We already send it to the BR, my lord. If your data is not received, my lord, some more time may be.
It's an outsider.
No, that's outsider.
Bihar,
But
actually.
other co-accused person, my lord, the two persons are there. He was released on interim bail, lordship's direction, my lord.
It has gone to Patangi.
My lord.
So are you expecting it next week or after?
ନାଇଁ ଛୁଟି ପଡିବ।
Chutti go. Land and Council for the state submitted. Address verification ହେଇଯାଇଥିଲା.
ନାଇଁ ଆର ଆଡ୍ରେସ ଭେରିଫିକେସନ ଯାଇଛି।
ଆଉ local security
ହେଇଯିବ।
By next week, by Monday, I'll
hand over them.
by Monday, I'll finish.
The Land and Council for the state submits that as per the କଣ order ହେଇଥିଲା ନା କିଛି
Order ହେଇଥିଲା।
Last
ଆମେ ବି ଚିଠି କରିଥିଲୁ।
ଏ order କେବେ ହେଇଥିଲା ଦେଖିଲା address
Order ହେଇଥିଲା
verification?
madam 27/21/7
21/7.
ଅଧା ତମେ କର ଆଉ ଅଧା କରନି। Huh? As per the order dated 21/7/2023, comma, for address verification intimation has been sent to the concerned authority, but the instruction is still awaited. The Land and Council for the petitioner shall furnish the names, address, and documents of two local sureties who are interested to take the petitioner on bail by next week, on receipt of which instructions shall be taken on the genuineness of the sureties and the authenticity of the documents to inspector in charge of Potangi police station of this matter on such and such date. Yes, next.
Grateful.
Item number 68.
Sixty.
52. Item 52. Just pass.
52.
Yes.
52 number.
My lord, this is the first bail application of the petitioner, and the petitioner is a lady, my lord. And while considering one BL appeal number 1286 of 2021, that is tagged with Lordship's file, my lord. Lordships enlarged three petitioners on bail and rejected two of them, my lord. 164 statement has recorded one by a witness, my lord, namely Rajiv Moduli. He has named who has granted bail, my lord. Bhagirathi, Kopila, and Chintamani, my lord. They have granted bail
What is this
by
item
Lordship, my
number?
lord.
So, when the five accused persons approached this court
My lord.
in BLAPL number 1286,
My lord.
you are not there
No, my
with
lord.
them. So, in that bail application, as I find,
My lord.
Except 1 and 5, I allowed the bail application of the other petitioners.
My lord.
And State Council submission on that day was that the statement of Rajiv Muduli was placed.
My lord.
So also Vishnu Muduli.
My lord.
And he also placed the postmortem report indicates that the deceased Chingi Muduli sustained one injury on the head,
My lord.
which was the cause of death.
My lord.
And deceased sustained 4 injuries on different parts of the body.
My lord.
And against 1 and 5, there were specific overtact attributed.
My lord.
Now, do you claim that you stand on the similar footing like
Yes, my
the
lord, because,
other 3?
Yes, my lord, because Rajiv Moduli named the 3 person who has granted bail, my lord. Bhagirathi, Kopila, and Chintamani. And so far, Vijay Mudali is concerned, he has already examined, my lord, but on not supporting to the prosecution story, I have also given the deposition copy, my lord. And this is the deposition copy of Vijay Mudali.
No, Vishnu Mudali.
Vishnu Mudali, my lord.
Vishnu Mudali turned hostile.
Yes, my lord. Those.
No, also supply the copy to the
Yes,
State
yes,
Council.
already supplied, my lord.
So, Mr. Tripathi,
Yes, my lord.
These 2 witnesses which were placed by you on the, so out of them, Vishnu Mudali has
Turn
not
hostile.
supported the prosecution.
But Bhagirathi Mudali, yes,
Rajiv
Mudali not examined yet.
Rajiv Mudali's statement ଅନୁଯାୟୀ ସେ କହୁଛନ୍ତି ରାଜୀବ ମୁଦୁଲିର statement ଅନୁଯାୟୀ a petitioner ଅର୍ଥାତ petitioner ନାଁ ହେଉଛି ତୁଳସା ମୁଦୁଲି. ତୁଳସା ମୁଦୁଲି case similarly situated like ଏ ଯୋଉ ଭାଗୀରଥୀ, କପିଳ ଆଉ ଚିନ୍ତାମଣି. So is it a correct statement? You are to verify.
Yes, Mullah, that is correct statement. Chintamani Muduli, Kopila Muduli, similar footing to Tulsa Muduli.
କିନ୍ତୁ ବିଜୟ ମୁଦୁଲି ନୀର ମୁଦୁଲିଙ୍କର ନାଁରେ ବୋଧେ ସ୍ପେସିଫିକ ଆକ୍ଟ ଅଛି ସେଇଥିପାଇଁ ମୁଁ ରିଜେକ୍ଟ କରିଥିଲି.
But this person Rajiv has told that Chintamani Muduli, Tudusa Muduli, Chingudi Muduli, Kamala Muduli, Tulsa Muduli, Ami Muduli, Vijay Muduli, Nira Muduli. That their name also find place.
No, specific overtake ତାପରେ ଥିବ ଦେଖ.
ନାଇଁ ତାପରେ କିଛି ନାହିଁ.
ନାଇଁ ତାହେଲେ ଆଉ କୋଉ statement ଥିବ ସେ ମୁଁ ଲେଖିଛି ପରା ସେଟା. ହଁ ଲେଖା ହେଇଛି ଏଇଟା ହଉଛି petitioner number 1 was armed with a ghagra and petitioner number 5 was armed with a pikasi and they assaulted along with the accused person. तामने सेटा सेमानक नारे गोटे ओमनिबस ऊपर थिला एई जो दी जन को मु रिजेक्ट कली सेमानक नारे ओवरटैक्ट रहितला मे बी दैट कोड कोन आपण प्लेस करथले से दिन तणु had the land and council for the petitioner land council for the state. This Tulasa Mudali is in judicial custody since when?
14/9/2020 मिलट
Huh?
14/9/2020
Submits that the petitioner Tulasa Mudali is in judicial custody since 14/9/2020. But you had approached this court earlier also? 6553 of 2022. That order you have?
no मिलट I am not that.
Yeah, बाहर करो.
No मिलट that is Kamala Mudali मिलट.
No.
Yes, I have that order. 6553.
Kamala Mudali, second one is the Tulasa Mudali. Petition number 1 is Kamala Mudali, 2 is Tulasa Mudali. This present petition. कौन बाहरी कर पान इसे कौन करूजी?
This is the order अच्छी मिलट. It does.
6553. जो एमाने सिस्टम असिस्टेंट जो माने आसीबे तम मोबाइल तम डिपोजिट करियो हला कोर्ट सरला पर लॉन्च रे दबो पुनी ये पर दबो हला scroll down. विष्णु मुदली स्टेटमेंट को रिलाय करी नि बेल आपन को रिजेक्ट करले आउटे ऊपर उठा औरी विष्णु मुदली कौन हला एग्जामिन हला नि?
Yes मिलट. That is PW5 I have supplied मिलट.
Who has not supported the prosecution case? All right, कौन लिख ले? And she is a lady and her earlier bail application in BLAPL number 6553 of 2022 was rejected as per order dated 31/10/2022. Taking into account the statement of one Vishnu Muduli, the London Council for the petitioner further submits that the said witness Vishnu Muduli has been examined in the meantime the trial court as PW5 and he has not supported the prosecution case. He further submits that some of the co-accused persons, namely Bhagirathi Muduli, Kapila Muduli, and Chintamani Muduli, have been released on bail by this court by order dated 8/9/2021 in BLAPL number 1286 of 2021. And the petitioner is similarly situated. and therefore the bail application may be favorably considered. Learned counsel for the petitioner files the deposition copy of some witnesses which are taken on record. Learned counsel for the state has produced the case diary and placed the statement of Rajiv Muduli and fairly submits that the petitioner is similarly situated like the co-accused persons Bhagirathi Muduli, Kapila Muduli, and Chintamani Muduli. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, nature of overact attributed against the petitioner, release of the co-accused persons on bail, and respondent's development made and a change in the circumstances made after the rejection of the earlier bail application of the petitioner, and for the taking into account the proviso to section 437(1) CRPC and the period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed.
Noble.
Item number 75.
Please, your lordship. Say evidence to them. Lords, in the meanwhile, 4 more witnesses have been examined, so I am filing copies. At the time of filing, 4 witnesses have been examined, which I have filed along with the bail application.
Is it the first application?
No, this is the 3rd occasion. First occasion it was refused. Second occasion, my lord granted interim bail.
First occasion in BLAPL number?
I am just submitting it. That is BLAPL number 5715 of 2020. Disposal date is 13/1/2021.
5715 2020 13/1/21. So and so charge sheet submitted. Occurrence took place on so and so date. It's a case of double murder of the deceased. Persons are Aditya Kumar Ran Singh and Bhagwan Swain. Prosecution case that while both the deceased along with so and so were coming together, the occurrence in question took place. Manas Ranjan Singh is an eyewitness to the occurrence, and he though implicated other co-accused persons in the assault of the deceased, but he has not stated about the presence of the petitioners in the scene of occurrence. Further submit that even though the said Manas stated that the main accused persons along with 4 committed the crime, but after arrest of the petitioner, so and so no attempt was made conduct TI parade, making so and so as an identifying witness. Therefore, okay. State on the other hand opposed the placed the statement of Pramod Behra, who along with so and so shifted the deceased so and so in an ambulance. On the way, the deceased Bhagwan Swain made dying declaration in which he has implicated both the petitioner as well as the co-accused persons in their assault. Further, summit is recorded by a person in a mobile phone, and that was also seized during course of investigation. It's a brutal murder of the deceased persons. One of the legs, each of the accused, was severed from the body. So and so. Yes, so it was rejected in 5715. Then what happened?
Then, your lordship, a petition for interim bail was moved in the trial court and rejected. Against that, I came in BLAPL 4980 of 2021. And there, I have annexed that order to the bail application, my lords may see, at page number 70. That is at page number 86, my lords.
In Trimble, he discussed about the merits of the case.
Yes. And your lordship was pleased to grant interim bail from 27/7/2021 till 16/8/2021. By then, trial had not commenced.
Okay, so now what is the position?
Now, my lords, 8 witnesses have been examined, and recently the presiding officer has been transferred.
Have
Now,
you
I have-
supplied the deposition copy?
Yes, yes. 4 witnesses I have supplied as part of the bail application.
Where is the copies of deposition?
They are annexure 2 series, my lords may see from page 58 onwards. They are the depositions of PWs 1 to 4 who had been examined by them. Then, and today I have filed copies of PWs 5 to 8.
What they have stated, Mr.
Now, my lords, the informant is PW2. Your lordship may see at page 61.
Injured eyewitness.
He PW?
2.
Acha.
Injured.
Injured
go there. Sorry. His evidence, my lords, he has not implicated. He is the informant. He did not implicate me in the FIR, nor in the statement which he deposed in court also. Your lordship may see at page 61, paragraph 2. He says, 5 lines from the beginning of para 2, 6 to 7 persons came out from the nearby jungle. When Pappu Pradhan, Jharia Pradhan and Baliya Pradhan of them came to us holding lathi and sword, assaulted to us mercilessly, but I managed to escape from their clutches. They also chased me, saying, Palaila, Palaila, Khasi Palaila, failed to apprehend me. After 2 kilometers, I informed the matter to my cousin Tuna over phone and called 108 ambulance to the spot. And then he says, after 2 lines thereafter, he says, we all proceeded to the spot, found the right leg of the deceased Aditya was cut and severed. The right leg of deceased Bhagavan was cut, but not severed. So he is a witness to the, not to the actual incident of assault, but just prior to that, because he claims that he escaped, and then he comes and sees. Then your lordship may look at para 4 of his evidence. During shifting of deceased Bhagavan to SCB, by ambulance, he disclosed before Prakash Naik and Pramod Behra about names of the accused persons, such as Jitu, Tera, Bharata, Jharia, Brahmara. I am named here. So this is the evidence appearing against me. Now, Pramoda has been examined as PW8. One of the persons before whom the alleged oral dying declaration was made. Now, PW8's evidence, my lords, I supplied copy today.
Yes.
If your lordship will see, what he says is, paragraph 2, on 15/2/2020 at 2 p.m. while I was present in my village, Pratap Behra of our village informed us that deceased, namely Aditya Ran Singh and Bhagavan Swain.
No, you come to the dying declaration.
Yes.
Paragraph 3, I think.
Yes, paragraph 3. Third line, during shifting the deceased Bhagavan to SCB MCH Cuttack, he disclosed the names of all the accused, namely Tera, Jitendra, Baliya, Kalia, Debba, Biranchi, Pappu, Rania, Brahmara Pradhan. Detained them at Joktalonji Dam by tying a GI wire from both sides of the road, assaulted them with sword and lathi, cut the right legs of both injured Aditya and Bhagavan, and severed the same.
So the evidence is consistent.
Yes, but it is omnibus.
But PW4 Miller, another witness to the dying declaration.
Dying declaration.
Yes.
Para 4. PW4, para 4.
PW4.
He has also similarly stated, my lords. And he has implicated against two persons specifically, he has stated. That your lordship will get at page 72. He says, on the way at Jokkalonji Dam, the road was blocked with a GI wire being tied on the trees from both sides. They got dashed with the said wire, fell down. Thereafter, suddenly all the accused, namely Prabhat Singh, Tera, Jitendra, Tariya, Balabhadra, that is myself, Viranchi, Debbo, Pandava, and names others. Oh, sorry, I'm sorry, Brahmara, I am Brahmara. Brahmara and Bharata came to them with having sword and lathi, assaulted them, but Manas managed to escape from their clutches. Thereafter, the accused, namely Pappu and Balabhadra alias Balia, cut.
The eyewitnesses are, there is no eyewitness to the occurrence.
No.
So it is oral dying declaration.
Yes. It is only the oral dying declaration, and even
prior
this,
to the occurrence,
there is enmity, political enmity.
PW2.
PW2 has stated that for 30 years, Millards, there is enmity between them.
No, what are the nature of injuries the deceased person sustained?
Injuries, Millards,
But they are both
limbs have been severe.
What is the name of the deceased persons?
Gote hela Aditya Ran Singh, ଆଉ ଗୋଟେ ହେଲା ଭଗବାନ ସ୍ୱାଇଁ। So far as
only leg severed or other injuries are there?
I am saying, so far as this person is concerned, Aditya, the injuries are on the leg. Cause of death is due to hemorrhagic shock as a result of excessive bleeding.
No, only leg injuries are
Yes,
there?
my lords. The postmortem report reads like this.
You are reading the PM report of who?
Aditya.
Okay.
Aditya external appearances aଜ୍ଞା ଲେଖୁଛି.
What about that Bhagavan?
ଭଗବାନ ର ଆଜ୍ଞା ହେଲା there are injuries. They are all swelling on the right forearm, abraded contusion on the right forearm, multiple small abraded contusions on the dorsum of the forearm, then swelling with fracture of the ulna, radius and ulna, abraded contusions of the forearm.
Mr. Tripathi.
Yes, sir.
If we go through this dying declaration, which has been made before, let us say, PW4
and 8.
PW4 and 8. PW4 says that he implicated number of accused persons, including, of course, this petitioner.
Yes.
But so far as that amputation part is concerned,
That is attributed to two persons.
Pappu Pradhan and Balabhadra alias Balia Pradhan.
Balabhadra.
So petitioner is not that person.
No.
And the cause of death was on account of that severing of
excessive
hemorrhage and shock.
How many criminal antecedents are there?
There are no criminal antecedents, so far as I am concerned.
What is the date of custody of this man?
18/3/2020.
Or the learned counsel for the petitioner, learned counsel for the state. Mr. Devasis Mandal, learned counsel, files appearance memo which is taken on record. submits that the petitioner earlier approached this court in BLAPL number 5715 of 2020, which was rejected as per order dated 13/1/2021. Is in judicial custody since 18/3/2020. The petitioner is in judicial custody since 18/3/2020, and when he approached this court for the first time in BLAPL number 5715 of 2020, same was rejected by the order dated 13/1/2021. Mainly taking into account the dying declaration, oral dying declaration of the deceased, stated to have been made before the witnesses, in which the name of the petitioner find place as the assailant of the deceased persons, namely Aditya 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 Kumar Ran Singh and Bhagwan Swain. The learned counsel submits that the petitioner approached again this court for interim bail in BLAPL number 4980 of 2021 on the ground of ailment of the wife of the petitioner, and the said bail application was disposed of on 23/7/2021, and the petitioner was directed to be released on bail from 27/7/2021 till 16/8/2021. The learned counsel further submits that in the meantime, 8 witnesses have already been examined in the trial court, including the informant Manas Ranjan Singh as PW Manas Ranjan Singh PW2, who has stated that while they were shifting the deceased
Page 61, my lords.
The deceased Bhagwan Swain to SCB Medical College, Cuttack by an ambulance. He disclosed.
He was not shifting, but PW2 was not there.
During shifting of the Swan Sobra Kaila?
During shifting, disclosure karagala, but not in his presence.
During shifting of the deceased, Bhagwan Singh to SC Medical College, he disclosed before Prakash Naik and Pramod Behera about the name of the accused persons who assaulted the deceased persons with sword and lathi, and the petitioner was named as one of the assailants of the deceased. The learned counsel further submits that the aforesaid 2 witnesses before whom the dying declaration stated to have been made, namely Prakash Naik, has been examined as PW4, and Pramod Behera has been examined as PW8. And PW4 Prakash
Page 73.
Naik has though named stated about the dying declaration made by Bhagwan Swain, in which the name of the petitioner finds place as one of the assailant of the deceased persons, but he stated that
Pappu
the
Pradhan and
Pappu Pradhan and Balabhadra alias Balia Pradhan caught the right legs of both the injured persons and severe. The PW8
paragraph 3.
Pramod Behra has also stated about the dying declaration made by Bhagwan Swai, in which a number of accused persons have been implicated, including the present petitioner, and but he has not specifically stated as to who caught the legs of both the deceased persons. The Land Council submits that even though in the your name is there in the FIR.
No, not named in the FIR. That I have annexed, annexure 1, my lords. I am named in the charge sheet after this incident. Page 11, my lords, please.
Mr. In the FIR, he has not been named.
No. FIR names Pappu, Jharia, Balabhadra and 4 others.
No, how to check for them. Mr. Tripathi, are you sure?
I am padi do page.
No, uncle, just janiya paise.
ପପୁ ଝରିଆ ବଳିଆ ମାରିଦେଲେ ଶୀଘ୍ର ପଳେଇ ଆସ ଏତିକି ଦେବୁ ଏତିକି ନା ଅଛି
Okay. This FIR was lodged after the deceased was shifted to the hospital.
No, during that period. As per PW2's evidence, he went to lodge the FIR, deceased was shifted to hospital. Because he had himself phoned the 108 ambulance.
I came to know during treatment on the same day that so-and-so, then we shifted both the injured persons to Banki for their treatment through one Bolero vehicle. One Pramod Behra so-and-so and accompanied them to the hospital. Subsequently, I came to know that on the same day that so-and-so succumbed to the injuries.
Tapare 5:30 p.m. went to Banki PS. Then lost FIR. Then he says during shifting of deceased Bhagavan to SCB.
Okay, then he was shifted. All right. The Land Council for the name of the petitioner doesn't find place in the past information depot, and in that view, the matter taking into account his period of detention in judicial custody, the bail application may be favorably considered. Land Council for the state oppose the prayer for bail and place the evidence of PW2, PW4 and PW8. However, it doesn't dispute that in the FIR, the name of the petitioner doesn't find place. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, the absence of any specific overtact alleged in the dying declaration, so far as the petitioner is concerned, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail allowed.
Obliged. Urgent copy.
Item number 76.
Please, my lord.
My lord, on behalf of Advocate Mr. Subhash Chandra Mahanti, I may be pursue this case, my lord. My lord, I am a petitioner is a lady, custody since 31/12/2019.
Wait,
And it-
wait, just a minute. This is item number?
76. PLPL number 5078 of 23.
Yes.
My lord, this is second time journey, my lord. Earlier rejected by your lordship on 2964 of 20 regular bail. My lord, while your lordship was directed to on that order, taking into account of period of detention of the petitioner in custody,
6 months time
6
was
months
granted.
time was granted, my lord.
What is the present status of the case?
My lord, out of 15 official witness, one witness has been examined.
Only one witness?
Only one witness.
So have you got any proof of that?
No.
Otherwise, status report has to be called for. You are supposed to produce the certified
my
copy of the order sheet. Lekhandu, the Land Council for the petitioner submitted that the petitioner is in judicial custody since 31/12/2019, and while rejecting the bail application of the petitioner for the first time in BLAPL number 2964 of 2020 as per order dated 25/1/2021, the petitioner was given liberty to renew the prayer for bail if the trial is not concluded within a period of 6 months from the date of receipt of the order. The Land Council submitted that he has received instruction that out of 15 charge sheet witnesses, only one witness has been examined in the trial court. However, since the Land Trial Council is not producing the certified copy of the order sheet of the Land Trial Court, let a status report be called for from the Land Trial Court. Matter to be listed after ensuing puja holidays with the status report.
Obliged.
Item number 77.
This is for third time the petitioner is moving them before this honorable court, madam.
First time?
Third time, you know. Is in custody since, my lord, 9/6/2017. The first bail application, my lord, that bail application number 8070 of 2017.
What is the date when you were taken into custody?
That is on 9/6/2017.
So what happened to in your earlier bail application?
The first application, my lord, that BLAPL number 8070 of 2017, was partly allowed. Two accused persons were there. One was allowed to go on bail. And so far as the petitioner is concerned, my lord, liberty has been granted to move after examination of the eyewitnesses. Thereafter, my lord, after the examination of eyewitnesses, my lord, the petitioner again renewed his prayer. That is in BLAPL number 923297 of 2018. On 25/2022, my lord was pleased to dispose of their application, giving 3 months interim bail, my lord.
Where is that order?
That order is availed that interim bail, and within the time stipulated, my lord, he has surrendered. The surrender certificate also have filed, that is an annexure 2.
So the eyewitnesses supported the prosecution.
Lordship, my lord, that is there, my lord, that eyewitnesses
Then,
will support the prosecution case.
what happened? You surrender at right time.
Lordship, my lord, that annexure 2, lordship, kindly have a glance, that surrender certificate I have filed.
Now thereafter, what is the position now?
Out of 20 witnesses, my lord, 14 witnesses have been examined, and the instruction what I have received, my lord,
ସେଟା ପରା ସେତେବେଳେ ଥିଲା 20/5/22 ରେ
ସେ ଏପ୍ରିଲ ସୁଦ୍ଧା ବି 4ଟା ୱିଟନେସ୍ ଏକ୍ସାମିନ୍ ହେଇଥିଲେ ଏପ୍ରିଲ 2023 ସୁଦ୍ଧା ତାପରେ 14 ୱିଟନେସେସ୍ ମାଇଲ out of 20 14 witnesses have been examined.
Mr. त्रिपाठी मु जेतेबेले 25/22 रे बेल देली आपनकू 3 मास पई सेतेबेले भी मु लेखिथिली जे 20टा चार्जशीट विटनेस रु 14टा विटनेस हेइचंदी
सेतिकी हेइचंदी
आउ हेनादी
no witness have been
have you got any proof of that
that is also there my lord lordship can have regards to the rejection order annexure 3 and page running page 17 man
कोठी देखिले
out of second para lordship can have a glance on perusal of the material students out of 20 prosecution witnesses 14 witnesses have already been examined that is of the order of April 2023 man
yes Mr. Are the learned counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submits. Petitioner was taken into judicial custody on 8/6/2017.
9/6 man
9/6/2017. And last time when he approached this court for bail in BLAPL number 3297 of 2018, by that time, out of 20 charge sheet witnesses, 14 witnesses had been examined and taking into account the period of detention of the petitioner in judicial custody. He was granted interim bail for a period of 3 months, and after availing the same, he surrendered at right time. He further submits that no more witness has been examined in the trial court, which would be evident from the rejection order. Land counsel for the state opposed the prayer for bail. Considering the submission made by the land counsel for the respective parties, in view of the evidence of the eyewitnesses being examined as 1, 2, 11, and 12, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention of the petitioner in judicial custody and the conduct of the petitioner in complying with the earlier interim bail order and slow progress of the trial, I am inclined to release the petitioner on interim bail for a period of 3 months. Disposed of.
Item number 79.
May I please your lordship, my lord. Well, here in this case, my lord, the petition moved first time before your lordship, and the main accused, principal accused, as well as
CD
another
available, Mr. Das?
co-accused person has been released on bail.
CD not issued, my lord.
CD9.
The principal accused and the my lord, another co-accused person.
But he has to verify and say that you are standing on the similar footing.
My lord, Your Honor, I am assisted. The allegation against the petitioner is that I have assisted the main accused.
अरे से केमती वेरीफाई करता कागज पत्र किसी नहीं ना
I will 376(3) rules যদি extra copy lordship kindly say
this is item number
79
79 79 is Subrata Panda and R.K. Parida. এটা ଆପଣଙ୍କ ପ୍ୟାଟର୍ନ ନୁହେଁ ବୋଧେ
89 sir.
ନନ୍ ଆପିୟସ୍ କରିଦିଅନ୍ତୁ
79 my lord, I have pass over on behalf of conducting counsel.
ନାହିଁ ପରା କାଗଜ ପତ୍ର ଦେଖୁଛନ୍ତି ଆପଣ the learned counsel for the state seeks some time to produce the case diary along with the criminal antecedent if any. List this matter after the holiday. Yes.
Item number 82. because he was unable to attend only one date, my lord. On the strength of NBW, he was arrested.
He did not abide by the terms and conditions fixed, my lord.
Non-bailable warrant of arrest was issued on 9/1/23.
Okay.
And you were taken into custody on
My lord,
17/6.
Yes.
Okay.
All right. Heard the learned counsel for the petitioner and counsel for the state. Belgium format रे कर देवे ताको. How he was on bail and non-bailable warrant of arrest was issued on 9/1/23 and he was taken into custody on 17/6/23. Baki allowed कर दो. Yes.
Oh, please. Item number 86.
My lord, your offense under section 302 and 332 of IPC. And
Case diary अच्छी रुहन्तु.
my lord,
Okay. Just a minute. BLAPL 7638/2023. And a fast bail application.
no, my lord. Earlier, the petition before your lordship in BLAPL number 1125 of 2021, BLAPL number 102 of 2022, and BLAPL number 10365 of 2022, my lord. And
कौन है लसुड़ा के?
my lord, ସବୁଥିରେ ଆଜ୍ଞା 3 ଥର ଯାକ interim ରେ ଯାଇଛି and he misutilized his liberty and he surrender in right time, my lord.
से order गुड़ा कहीं?
Order ଗୁଡାକ ନାହିଁ।
Order गुड़ा बाहर करे आनी हाई कोर्ट वेबसाइट रे नहीं.
କାହିଁକି ସବୁଦିନ 5 minute
पासो और कौन इट साइंस बाहर कर देवे ना कौन प्रिंटर मशीन नहीं किन बुलचंती ना.
ବାହାରି
हाँ तो पासो और करो. Next.
Item number 87.
May please. Petitioner custody my lord 12/12/2019 my lord.
Wait.
All the co-accused person already released on bail, my lord. Only confession before the police, my lord. Who confession before the police, my lord, already released on bail, my lord.
Wait. 91 BLAPL 7739 2023.
91 to.
So is it your first application?
I am appealing for second application.
Second
My
application.
lord.
So what is the earlier application?
Reject my. Bahala only disposable reject.
What is the number?
Mention my lord in the bail application. And BLAPL my lord 979 9795 disposed on 22/2/2022
क्या ऑर्डर कहीं
ऑर्डरटा देखो ना अपलोड खाली डिस्पोजेबल
हाँ केबे केबे रिजेक्ट ହେଇଛି
22/2/2022
no what is the number
9795 2019
2019
my lord
dispose of ହେଇଛି
22/2/2022 ର डिस्पोज
and you are in custody since
my lord I am the custody 30/4/2019
charge sheet under section
302/120B my lord
302
120B
date of occurrence
date of occurrence my lord अट्ठाईस 4/2019 only one Chandana Panda my lord co accused confession before police petitioner along with other
there are no eyewitness to the occurrence
no my lord
huh?
no eyewitness my lord. And last Chandana order my lord and unnecessary co accused order
Chandana Ponda
my lord as for a rejection order my lord page 20 unnecessary page 20 counted case 302 and 20 BIP the principal accused
you are a man from West Bengal
my lord
address has been verified Mr.
no my lord.
And is it correct that only statement only material is the co-accused statement
My lord.
okay you verify the address and you furnish the local sureties to the state council the learned counsel for the petitioner submitted that the petitioner is in judicial custody since 30/4/2019 and he has been charge sheeted under section 302/120B of the Indian Penal Code and there are no eyewitnesses to the occurrence and the entire case of the prosecution against the petitioner is based on the confessional statement of co-accused Chandana Panda before police which is not disputed by the learned counsel for the state. Apana kon kହୁଛନ୍ତି?
My lord, while he is in the custody, he is threatening the petitioner. My lord.
Stop. The learned counsel for the
One case.
informant, however, apana power ଦେଇଛନ୍ତି?
My lord.
Acha, so and so Sarada Prasad Das and his associates have filed power for the informant,
My lord.
which is taken on record. The learned counsel for the informant submitted that he is giving threat.
My lord. The case is registered one.
Jail le prachi.
Jail ରୁ ଆସିଥିଲେ ସାକ୍ଷୀ ଦେବାକୁ ସେ
हाँ
jail ରୁ ଯେତେବେଳେ ସାକ୍ଷୀ ଦେବା ପାଇଁ ଆସିଥିଲେ କୋର୍ଟ ରେ ସେଟ୍ କରିଥିଲେ.
କୋର୍ଟ ବାରଣ୍ଡାରେ
My
ଟ୍ରାଏଲ କୋର୍ଟ କୁ ଜଣେଇଥିଲେ ଟ୍ରାଏଲ କୋର୍ଟ କୁ ଜଣେଇଥିଲେ ଆପଣ ସାକ୍ଷୀ ଦେବାକୁ ଆଇଛନ୍ତି ଆପଣ ଓକିଲ ଏନଗେଜ କରୁଛନ୍ତି ହାଇକୋର୍ଟ ରେ ସେଠି ଏନଗେଜ କରୁଛନ୍ତି ନା ନାହିଁ ଟ୍ରାଏଲ କୋର୍ଟ ରେ
ସେଟ୍ କରୁନ.
କଲେନି ଆଉ ସାକ୍ଷୀ ନହେଲେ ନିଶ୍ଚୟ କହିଥାନ୍ତା ଏଠିକି ଯାଇକିନି ଯେତେବେଳେ ସାକ୍ଷୀ ଦେଇ ସାରିଲେ ନା ସାକ୍ଷୀ ଦେବେ?
ଦେଇ ସାରିଲା ପରେ
ଦେଇ ସାରିଲା ପରେ threaten କଲେ ନା ଦେଲା ବେଳେ threaten କଲେ?
ସାକ୍ଷୀ ଦେଇକି ଆସିଲା ପରେ
କୋର୍ଟ କୁ ଜଣେଇଲେନି, ଟ୍ରାଏଲ କୋର୍ଟ କୁ? The learned counsel for the informant, however, threatening, submitted that the petitioner has given threat to the informant after he deposed in the trial court. However, he fairly submitted that no intimation has been given to the trial court in that respect. Learned counsel for the state, however, submitted that the petitioner is a man from Murshidabad district in the state of West Bengal, and he may be given some time to verify whether the address furnished by the petitioner in the cause title is correct or not. Let the SP so contact with so and the learned counsel for the petitioner shall also furnish the names, addresses and documents of two local sureties to the learned counsel for the petitioner by the next week, which will be sent to inspector in charge of Baripada Police Town Police Station for verification. List this matter after ensuing puja holidays, indicating the names of the learned counsel for the informant in the cause list.
Item number 92. May I please your lordship? Item number 96.
May I please, my lord. My lord, this is the second bail application, my lord. Earlier bail application was rejected and given liberty to the petitioner to renew the prayer for bail if the trial not concluded within the 6 months after charge frame. My lord, charge has been framed on 11/10/22. 12 months have been passed. Only 4 witnesses from the out of 19 official charge sheet witnesses have
Have
been
you got
examined.
the certified copy of the order sheet?
I have deposited. I have filed, my lord.
What you have filed?
I have filed, my lord, since last 4 days. I have got the deposition copy. I have filed the certified copies.
I'm telling about the certified copy of the order sheet of the land and trial court.
No, my lord, only deposition copies.
The land and counsel for the petitioner submit that the petitioner is in judicial custody since Kevedu,
My lord, 8/1/22.
8/1/2022, and in the trial court only 4 witnesses have been examined.
Yes, my lord.
4 witnesses have been examined. Status report we called for. Yes, next.
After puja vacation, my lord.
Obviously.
Okay.
Item number 100.
Yes, ma'am.
100, my lord. My lord, allegation as per FIR is that some gold, the petitioner is the assistant branch head of the Manapuram Gold, my lord. My lord, allegation as per FIR is that some gold ornaments were stolen from Manapuram Gold Finance Limited, Nachoni branch. Entire allegations, my lord, against branch manager named Sachin Pradhan. Because my lord, petitioner was assistant branch manager, police implicated her in this case. Rather, petitioner have several times informed to head office of the bank regarding misappropriation of gold ornaments. My lord, that is letter dated 5/8/21 and 12/2/22. That is, my lord, I have annexed it to page 5 to page 6, my lord, and other WhatsApp chat with the head office. In meantime, my lord, trial has been commenced and informant Ajay Kumar Lenka have been examined, and he clearly stated that after audit inquiry, accused Sachin Pradhan admitted his guilt and prayed for some time to repay all the default amount. My lord, and in para 12 I have mentioned it, my lord, of the deposition of the informant stated that around more than 12 months, 2 months have been of having 2 months of lodging affair. The assistant branch head Savitri Pradhan petitioner intimated to the head office regarding misappropriation caused at Nachuni branch and caused by the accused Sachin Pradhan. I have already intimated this, my lord.
No, merely because you intimate, that doesn't absolve you from the crime টা করলা পরে ଆଉ ତାପରେ intimation ଦେଇଦେଲେ
Prior to crime, my lord, ମୁଁ ଦେଇଛି.
How the gold ornaments would go away from that company? You are in charge of that. You are in.
I am the assistant branch manager.
So what?
Main allegation against the Sachin Pradhan, the main branch head, my lord.
So what about the recovery of the gold ornaments? And what happened to the other main accused you are saying? No, what happened to that main accused you say? Sachin Pradhan na ko.
No, he custody.
So surrender and move for bail. Why anticipate?
My lord, let me come after vacation so that I will get instruction from my client whether some of the ornaments which has been found misappropriated by the branch.
You have got the case diary?
No, yes.
Land counsel for the state seeks some time to produce the case diary. After vacation is next.
Item number 104.
104 may I please?
110.
Sorry. TDHE
Yes, my lord.
110.
Yes.
Yes, pass over next.
Item number 118.
May I please your lordship?
17 mentioned.
May I please
Item
be
number
lord?
117.
17.
18 to
My lord.
Here, my
CD
lord.
available?
Yes.
Price your lordship granted in your entry bill 3 months, my lord. 3 times, my lord.
Last time?
And last time, my lord, in BLAPL number 11120 21, my lord. And availing the entry bill, he has surrendered on 28/3/2023. Thereafter, moved to bail, my lord. That is available,
11120 of 2021 is the last application.
my lord. Prior to that, my lord, in the 87/4/5 of 2019, the lordship granted him 3 months bail and entry bail. And thereafter, 15/7/5/2021, also granted 3 months, my lord, entry bail.
So case ର position କଣ ବର୍ତ୍ତମାନ?
Lord, 11 witnesses have already been examined, my lord.
302 case.
My lord. The allegation that, my lord, this is taken money from the petitioner, my lord, in order to purchase some agricultural materials. My
What
lord.
evidence has come against you?
Lord, most of the witnesses, my lord, declare hostile, my lord. Like PW2 declare hostile, and
PW3 and PW11 are the eyewitness, man.
ହଁ କଣ କହିଛନ୍ତି ୟା ନାଁରେ?
Yes, sir. PW3 is the niece of the deceased and
PW3?
my lord, and
ठीक है।
PW11 is the wife.
PW3 ତ କି ଦେଖା ଯାଉନି କଣ ଏଟା କଣ?
ଦେଖାଯାଉନି, but PW11 is clear, my lord.
PW3 ର evidence ଅଛି?
ସାର୍ଟିଫିକେଟ ଗୋଟେ ଅଛି।
ହଁ legible copy ଦିଅନ୍ତୁ ତାଙ୍କୁ ବି ଦେଇନାହାନ୍ତି।
ସାର୍ଟିଫିକେଟ ଗୋଟେ ଅଛି।
PW11 ଟା ବି eyewitness।
ଆଚ୍ଛା 11ଟା ହଁ 11ଟା କଣ ହେଲା ପଢିଲେ?
The informant Ricky Roida is my niece, PW3 ତା ମାନେ Ricky Roida, being daughter of my brother-in-law Krishna Roida. The deceased Nandu Roidas was my husband. I know both the accused person Virupaksha Ponda and Rinku Sahu, present through BC, who belong to first camp of Hirakud. The occurrence took place
ଇଏ ହେଲା ବିରୁପାକ୍ଷ।
my lord. The occurrence took place on 4/1/2017 in the dusk hour near the house of Pina Rohidas. On the same day, at about 5 p.m., Pintu Maji had been to my house, and at that time, he had demanded my husband to repay the money lent by him from Virupaksha Ponda. At that time, my husband told him that he will repay the amount later on. Thereafter, Pintu Maji left our house. Thereafter, Pintu Maji telephoned Virupaksha Ponda and Rinku Sahu. Sometime thereafter, Pintu Maji, Virupaksha Ponda and Rinku Sahu arrived at my house, raised shout and searched for my husband in our house. As my husband was not available in my house, all three of them left. While returning, they met my husband near the house of Pina Rohidas. They picked up quarrel with my husband. Hearing commotion from the side of the house of Pina Rohidas, calling my niece Rinki Rohidas the informant, I rushed toward the house of Pina Rohidas. There I saw, while my husband was leaving the spot, the accused person caught hold of him and gave blows to him by a sharp cutting weapon like a knife. They gave blows by means of the weapon on the face of my husband, near his ear, neck, hand, legs, belly, and back. Thereafter, the accused person threw the body of my husband on a nearby land. Then the accused person left by means of a scooty and a bike. I tied the bleeding wound of my husband by means of sari. I, along with my niece, brought my husband to our house.
So the eyewitnesses are there.
PW3 is there, but it is not legible.
So last time you were granted, that is the reason perhaps you are not granted bail on merit, but so when you were granted last time in 11/1/11/20 of 2021.
Nonetheless, having 5 CAs also, man.
Huh?
5 criminal antecedents. And 302 is also one.
No, but he was granted interim bail because
Thrice.
he was
Thrice
in
he was
custody
there.
since 2017. ଛଅ ବର୍ଷ ଆପଣ ଟ୍ରାଏଲ ସାରୁନାହାନ୍ତି ଏପର୍ଯ୍ୟନ୍ତ 11ଟା ୱିଟନେସ୍ କରିଛନ୍ତି ସାକ୍ଷୀ ଟୋଟାଲ କେତେଟା 6 ବର୍ଷ 9 ମାସ ହେଇଗଲାଣି ଅଲରେଡି
Total 17 charge.
ହଁ
20 charge.
20 ରୁ 11ଟା ହେଇଛନ୍ତି ଲାଷ୍ଟ ୱିଟନେସ୍ କେବେ ହେଇଥିଲା PW11 ଟା
26/4/2023
ତାପରଠୁ ଆଉ କଣ ସାକ୍ଷୀ ହେଇନାହାନ୍ତି
ଆଉ ରେଜିଷ୍ଟ୍ରେସନ
are the learned counsel for the petitioner and counsel for the state submitted that petitioner was taken into judicial custody on 6/1/2017 and he was granted interim bail thrice by this court. And the last time he was granted interim bail for a period of 3 months in BLAPL number 11120 of 2021 as per order dated 20/12/2022. And after availing the same, he surrendered at right time. And since only 11 witnesses have been examined out of 20, there is delay in disposal of the trial, the bail application, the interim petitioner may be granted interim bail. Learned counsel for the state opposed the prayer for bail, 3 months bail granted. Yes.
Disposal.
Disposal.
Item number 118.
Please, Your Lordship. Lordship, the petitioner is in custody since 8/9/2020 for alleged offence under section 147, 148, 302, 307, 120B, 353, and 149, read with 20B, 2C, 25, 27, and 29 of NDPS. Lordship, meanwhile, all 2 co-accused have been released on bail, Lordship. Lordship, the FIR story is that around 100 people were carrying contraband on a balance stick, each carrying 2 contrabands bag which contain 13.5 grams each, Lordship. And subsequently, when the police person came to the spot and seeing the police personnel, the 100 people attacked the police personnel and one of the homeguard succumbed to death, Lordship. Subsequently, 37 persons were apprehended at the spot, Lordship.
Is it your first application?
No, Your Lordship. Third journey, Lordship.
So what has happened in the other two?
It was rejected, Lordship, because of commercial quantity of ganja. And
So what is the change in the circumstance?
Lordship, co-accused who stands on a similar footing to this petitioner have already been released on bail, Lordship.
No.
And out of 60 witnesses, only 9 witnesses have been examined.
The bail application was rejected after the examination of those witnesses.
No, Your Lordship, prior to that.
When it was rejected?
Lordship.
That was it was rejected on 28/9/2021.
One in the year 2023, Lordship.
Lordship,
that is
what is the order?
4296 of 2022.
What is the order sheet?
Lordship, I haven't annexed.
What is the order? देखिए order टा बाहर कर ले कितना नंबर कौन दो
Lordship, 4296 of 2022.
4296.
Yes, Lordship, of 2022.
22.
Dated
Disposed of on
1/3/2023, Lordship. Hmm? 1/3/2023.
4296 pra उनसे टिप्पी की रोकना देना कौन हाँ Subhas
Banman,
right. Scroll down. No, the order dated 1/3/23. Adu upru uthela kebe disposal ହେଇଛି he is right in 1/3/23 but that order is not there. It was disposed of. You are also the counsel there.
Yes, Lordship.
Where is the order copy? It is not been uploaded there.
Lordship, I will file the copy, Lordship.
You file it. The learned counsel for the petitioner submits that the last bail application of the petitioner in BLAPL number 4296 of 2022 was rejected by this court on 1/3/2023 and you will file the copy of the order by next date, giving copy to the learned counsel for the state. List this matter after ensuing puja holidays.
Item number 122. My lord. Item number 121, my lord. 21.
May I please? Yes.
My lord, item number 120, my lord.
120, it a mention is like the matters which were mentioned yesterday, only those matters have been taken off. State Council has brought the case diary only in those cases. Your matter you have not mentioned, so it will come next week in the weekly list.
Okay, my lord.
Okay. Yes. What is this matter? 122 minutes. 122 BLAPL 8531 of 8531 2023. First bail application or earlier?
Second bail application.
Agota kon hitla?
Annexed to page 14 minute. The relevant page at page 17.
17.
After examination of the extrajudicial confession, witnesses to the minute.
Kon hala botan?
They have already been examined. They have turned hostile. I have given the deposition of PW1 and 2 minute.
Kain?
Page 18 and 18, 19 and 20 minute.
ଆଉ କିଛି ନାହିଁ
ଆଉ କିଛି ନାହିଁ
ଡାଇରେକ୍ଟ ଏଭିଡେନ୍ସ
ନାଇଁ କିଛି ନାହିଁ ଅନୋନ୍ ଏଫଆଇଆର
Sir, I have to check this one.
ଅର୍ଡର ଟା ଦେଖୁନାହାନ୍ତି
ଆଜ୍ଞା ଦେଖିଛି ସିଡି ସାଇଡ୍ କମ୍ପେୟାର କରିଦେବି ଯେ these are the person extrajudicial confession ଏଇ ଲୋକର
ନାଇଁ ନାଇଁ ଅର୍ଡର ଲେଖା ହେଇଛି
ଲେଖା ହେଇଛି ଅର୍ଡର ଲାଷ୍ଟ
ୟୁ କମ୍ ଟୁ
17 page 17
ଏଇবার ଲେଖା ହେଇଛି କପି ବୋଧେ
ପହିଲମାନ
ଅର୍ଡର
ପହିଲମାନ ମୁଣ୍ଡା ଆଉ ମୁନି
wait
ମୁନି ଦେବୀ
the main circumstance is the extrajudicial confession of the petitioner before one କଣ ପାହାଲିନ ମୁଣ୍ଡା
କହିଲ ମୁନି ମୁଣ୍ଡା
which is alleged to have been made on 3/1/2022
my lord
but it is disclosed before the police for the first time on such and such date.
my lord
So your objection was a man from Jharkhand.
my lord
আচ্ছা ঠিক ଅଛି ଝାରଖଣ୍ଡ ଲୋକଟା
ଆଜ୍ଞା
ତାହେଲେ ଗୋଟେ କାମ କରନ୍ତୁ ଆପଣ ଆଡ୍ରେସ ଭେରିଫିକେସନ
ଅନ୍ୟ
କରିଦିଅନ୍ତୁ
କୋଆକି ଗୋଟେ ବେଲ୍ ବି ଯାଇଛି ସିମିଲାର ଫୁଟିଂ ରେ ମାନେ ଡବଲ କୋଆକି ମାନେ
so this is item number address verification ହବ ହେଲା ତାପରେ CD produce କରିବେ criminal antecedent ଆଣିବେ ଆଉ local surety ଦେବେ ସେଗୁଡାକ verify ହବ after vacation.
ସିମିଲାର ଅର୍ଡର ଆଉ ଗୋଟେ ହେଇଥିଲା କୋଆକି ମାନେ
Yes, next.
address verification ଦେଲା ପରେ
ହଁ ନାଇଁ ସେ ଏକାଥରେ ନେଇଯାଆନ୍ତୁ ହେଲେ ଯଦି ଠିକ ଠାକ ଥିବ ଆଡ୍ରେସ ଆଉ ବେଲ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଏଇ ଗ୍ରାଉଣ୍ଡ ରେ ଦଉଛି ତ ଆଉ ରିଜେକ୍ଟ ହେଲା ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ୱିଟନେସ ଗୁଡାକ ହୋଷ୍ଟାଇଲ ହେଇଗଲାଣି
ଆଜ୍ଞା
ତେଣୁ ଏକାଥରେ ଆପଣ ଭେରିଫାଏ କରିଦିଅନ୍ତୁ ସେ କାମ ପାଇଁ ଏସପି ପଠେଇବେ ଏଇଟା ଆଇଆଇସି ଜରିଆରେ ସେ ଦେବେ କମିଂ ୱିକ ରେ ଦେବେ ସେ ତାକୁ ଲୋକାଲ ସିକ୍ୟୁରିଟିଜ ଗୁଡା ଦେଇଦେବେ ନେମ୍ସ ଆଡ୍ରେସ ୟେସ୍ ନେକ୍ସଟ
ଆଜ୍ଞା ପ୍ଲିଜ
ଏ ଟାଇମ ହେଇଗଲାଣି ତ ବାକି ଗୁଡା ସବୁ ନେଇ ଆସିବ ସବୁ ଆସିବ ନେକ୍ସଟ ୱିକ୍
ଯୋଉଟା ମେନସନ ହେଇଛି ଉପରେ ସେଗୁଡା
ସବୁଗୁଡା ଆସିବ ନେକ୍ସଟ ୱିକ୍ ମାନେ ଆଉ ଗୋଟେ ଥର ଆଉ ଥରେ ମେନସନ
Item 99 may be taken up next week.